Recording in progress.
Good afternoon. This is it is February 10th, and it's approximately 5:01 p.m. This is a meeting of the board of the Civilian Police Oversight Agency. I'd like to welcome you and call this meeting to order. We have a quorum of members present. Member Jesse Crawford, member Eric Nixon, and member Patricia French, and I'm acting chair Bill Cass. So if our mission statement for this organization is advancing constitutional policing and accountability for APD in the Albuquerque community. Before I continue, I'd like to also mention who we have. We have present else other than the board itself. And I'll just kind of go down the list from participants. From APD, we have Acting Commander Jason Sanchez. We have Ali Abbasi from the CPOA, Amanda Chino Zamora, who's a potential new Carl Vigil, who I not received any information about. Carlos Pacheco from the city, Chris Sylvan from the city, Elizabeth Martinez from the DOJ, Jared Hager from the US DOJ, Kelly Mensa from the CPC, Martisa Billy from the CPC, Michael Wartel, who is also another potential board member, Richard Evans from APD, and our counsel, Tina Gooch, as well as Valerie Barella. And what happened to Katrina Segala? She was here a minute ago. So if I'm, oh, there are more. Okay. That's all I can see at the moment. So we're back to the agenda. We're at item 3, approval.
Excuse me, Chair Cass.
Yes.
I had messaged you. Can you just state for the record if Member Galloway is excused from the meeting?
All right. And so the 5th active member of the board has been excused from this meeting. So that constitutes the complete board as we know it, as we have today. All right, so we're at item 3, approval of the agenda. And so if I could have a motion to approve the agenda for today. Is that a motion? All right, I'll second the motion. So I think we need a roll. Will you call the roll, Ms. Barella?
Member Crawford? Member Crawford? Thumbs up could give a yes in the interim. Thank you. Member French?
Yes.
Thank you. Chair Cass? I'm not hearing anything from Chair Cass. Is anyone else?
Okay. I'm sorry.
There you are. I can hear you now.
All right. Okay. I won't turn myself off. This is practice in muting. So
So it's the roll call for the agenda. Member Cass?
yes.
Okay, thank you. Member Nixon?
Yes.
Thank you. That motion passed on a vote of 4-0. Thank you.
All right. We're at item 4, public comments, and there were no public comments submitted this evening. So item 5, review and approval of the minutes from the January 31st special meeting. So if I could have a motion to approve minutes from the January 31st meeting.
I'll make a motion to approve them. They seem accurate and in order.
I'll second. So, Miss, are there any comments on the minutes from January 31st? If not, Ms. Barella, will you call the roll, please?
Member Crawford? Thank you. Member French, thumbs up for Member Crawford. Member French,
Yes.
thank you. Dr. Cass,
Yes.
Member Nixon,
Yes.
thank you. That motion passed on a vote of 4-0.
Okay, we are now at item 6, reports from city department. And first up is APD, the IA Professional Standards Division, Commander Cottrell, and I believe we have someone substituting for Commander Cottrell this evening. So I'm
Yes, sir. It's Acting Commander Carl V. Hill here, right for Zach Cottrell.
thank you. Go ahead, please.
Sure. So for the month of January 2022, our total cases completed is 17. We have 14 cases completed and sent for discipline review. The IA cases opened for the month of January currently is 24, or is 24 because we're in February now. Area Command IA cases opened is 30 for January. And then pending IA cases for the month of January still is 22. So that's our carryover. No cases mediated. All the statistics seem pretty usual for what we've been experiencing lately as far as caseload goes. So it's just been business as usual as far as that concerns, sir.
Thank you. Are there any questions from the board? I would like to just point out that, and maybe this is directed in part for Member Nixon, is this is an opportunity, I believe, to get answers to the kind of questions you've raised in the past about the disposition of cases of discipline. And so discipline is mentioned in this report, and there is some insight into the process of discipline, although names are not mentioned as the way it's described. I mean, the way it's intended, and but it does give some additional information about the fact that discipline was imposed in particular cases or not. So I just wanted to point that out. Any other questions, comments from the board? Seeing none, then we will. Is that you, Member Nixon? Did you have a question?
I did not. Thank you.
Oh, okay. I'm sorry. I thought you were. All right. Seeing no further questions, then we will go to IA Force Division, Commander Richard Evans, or Acting Commander Richard Evans.
Good evening, everyone. Getting my paperwork settled here. Just 1 second, please. Okay, so I have the stats for January 2022, and keep in mind that this is out of approximately 36,000 calls for the month of January. So looking at January 2022, let's see, dispatch calls for service with no bolos. We had exactly 36,000 calls for service. We had 41 uses of force total out of that 36,000 calls. For level ones, I'm just going to go over out of the leading area commands because it seems to get a little routine and mundane for me just to call out the numbers unless you all want me to. I think you all have a copy of this. But the Southeast is the leader in number ones with 4 uses of force. The Southeast is also the leader in level 2 uses of force with 7 level 2 uses of force. And the Southwest is the leader in level 3 uses of force with 2 level 3 uses of force. As I said, we had 41 total uses of force for the month of January, and force per 1,000 calls for the foothills is 0.8. For Northeast, it's 0.5. The Northwest, 1.1. Southeast was 1.2. Southwest was 1.2, and Valley was 1.1. That's force per 1,000 calls. With that said, I'll go ahead and go briefly over each area command. The foothills with 3 level 1s, 1 level 2, 1 level 3. Northeast with 2 level 1s and 2 level 2s. Northwest with 2 level 1s, 2 level 2s, 1 level 3. This is that mundane sort of routine talking I was telling you all about. Southeast with 4 level 1s, 7 level 2s, and 1 level 3. Southwest with 1 level 1, 3 level 2s, and 2 level 3. And Valley, 3 level 1s, 4 level 2s, and 1 level 3, with 1 at the PTC. The top 3 incidents that we've used force on is we had 14 with a family dispute, 5 for a disturbance, and 4 were suicide. So not a big change on any of that. And then if you look at the 12 months of force data, we are exactly in line with historical numbers. For December, we had, like in the foothills, we had 5 last month, we have 5 this month. Northeast, we had 6 last month, we had 4 this month. So I don't see any disturbing trends or anything jumping out at me that I would be overly concerned about. Everything seems to be kind of status quo as far as the stats. Does anybody have any questions for the IAFD report?
Not necessarily a question, just a quick comment. It would be okay. I'd probably be good to flash those on the screen as you're kind of reading through them.
Oh, share screen?
Yeah, just
okay,
because there may be people that didn't get the report, and it just kind of keeps us on the same match with you as you're going through it. But I mean, your
sure thing.
Yeah, your presentation was fine. I mean, I was able to follow along, no worries. But maybe we could.
I'll be glad to do that. Absolutely.
Awesome, thank you. And this is, maybe I'll go somewhere else to try and figure out how this is how things are going. But based on the statistics, Officer Evans, in your opinion, how are the officers holding up? As far as, it's not like the work is getting lighter, right?
Yeah.
Just kind of checking in with them to see how the officers are holding up in the field regarding, these so many calls and etc.
Well, it's busy. It's, that hasn't changed for a couple of years. We keep getting busier and busier because the staffing has gone down. We've been really public about losing so much staffing. The morale, I mean, they're hanging in there. Morale could always be better, but I can honestly say I've never seen APD working harder to try to make everyone happy, the DOJ happy, the public happy. In my 20 years of service to this city and from my lifetime of living here, I mean, I'm impressed with what the officers at the ground level, the boot level, what they're doing to try to make things work. Whereas back in the day, if you messed up, you had your supervisor just bring correction, teach you the right way of doing it. Now you end up in IA for that same mistake. But it's a learning process, and they seem to be adapting well. But I would imagine it's still going to take some time for them to kind of get in the routine of things, and that's when you really hit that stride when people know what to expect from IA, and IA puts their expectations out there consistent. And what we've had over, what I'm the 5th commander for IAFD, what you've had is this kind of inconsistency and different ways of doing things. Well, now they've had 6 months of me just kind of with the same consistent message, the same consistent identification of problems in force, EFIT identifying those same issues. And I think they're starting to get used to knowing that and knowing what to expect. We also started sending out letters to let officers know when their force has been completed and whether it was in policy. So that should help morale a bit, so they don't have to sit around waiting.
All right, thank you.
Oh, you're welcome, sir.
Other questions from members of the board? Member French.
I just want to say, yeah, that's a tremendous amount of calls, 36,000. Now, does that also include the duplicate calls and the ones referred to TRU?
All of these calls here were dispatched.
Okay, so there's none of those calls that went to the telephone reporting unit?
No, this says dispatched calls for service was 36,000 calls, and I removed all the bolos which are be on the lookout for.
Okay, so my second question is, that's a tremendous amount of calls. How many officers are actually taking calls for service? How many were actually bid? I guess not the detectives, but the ones that actually bid.
Gosh, I don't have that stat for you. I want to say it was, gosh, I think I would be doing you a disservice if I guessed.
Okay, next month is fine. If you could just get me that information by next month.
Sure
How many
thing.
were on the bid?
Sure thing.
That's
If I
a
may
lot of calls.
interrupt. If I may interrupt, my name is Amanda Chino Zamora. The bid for officers usually takes place in March of annually, and the radio communications is one of the first ones to receive it. So you might want to check with Erica Wilson to get the printout of how many officers are going to bid.
Thank you. Is anything else, Member French?
No, that's it.
If you guys wouldn't mind, if because we have other people watching this session, could you explain the bid process briefly, Member French?
Sure. They open up positions in the field. So they open up the positions in the field for the amount of officers that they have available to bid. The bid process starts, of course, with the lieutenants. And then on a separate day, they will bid for sergeants. So those sergeants will be able to bid for their lieutenants and their area command based on their seniority. And everything's based on seniority, the way we do things. And then lastly, we have all of the officers bid for their sergeants and their area command. Yeah.
And this is for shifts?
Yes, per shift and area command and supervisor. So those that are brand new typically end up at the bottom of the list. But I know that APD in the past has placed rookie officers. They've had special positions for rookie officers to go with more senior squads. Like you may have all of day shift weekends off, with senior officers with 20 plus years. And historically, they would be all senior guys. And I know that APD in the past has put rookie officers in those squads or had a mini bid for them. I don't know if that took place this year, but I can certainly check with ops.
Thank you.
Certainly.
Any other questions from the board? I have one, and that is, I noticed that there was one use of force associated with the SWAT call out. How were SWAT call outs changed recently, or if at all?
So we've come up with a special order where we're going to be working with when outside agencies use force on our SWAT calls, how we're going to go about investigating those and for our personnel, which basically includes how we gather our information and reports and things of that nature. Other than that, I mean, we still investigate them similarly than we do all of our other force. However, in the future, I would like to have more specialized officers dealing with SWAT callouts, K9 callouts, OISs, things like that. I wanted to address a comment made by Jarrett Hager. Maybe I misspoke, but the comment he took issue with me saying, IFD wanting to make everyone happy. It's not IFD wanting to make everyone happy or anything like that. It's the field trying to make everyone happy And what I mean by that is they're trying to follow the rules. They're trying to make IFD happy by following the rules of force. They're trying to make IEPS happy by following SOP. It's like any job to a degree. Of course, they want to police, and they took this job because they want to serve their community and do a good job. That's a fundamental reason why most of us became police officers. But when you get the job, your goal is to make your boss happy. And you do that by working hard and obeying the rules. And that's what I meant by that. I meant no derogatory term against enforcing organizational values or anything to that nature.
Thank you. Any other questions or comments from the board? Seeing none, I'd like to thank you again for being here. I think actually the IFD report is one of the most important reports that the board gets every month, because I think that's the fundamental reason that we exist as an oversight agency. So thank you again, and on.
Absolutely.
So the next item on the agenda is a report from City Council, Chris Sylvan. So Mr. Sylvan.
Excuse me, Dr. Cass. Sorry, Chair Cass. Sorry, Chris Sylvan. The third item under APD was APD training semi-annual report that was postponed. I just want to put that on the record.
Yes, thank you. So yes, as Ms. Barella mentioned, the APD training semi-annual report was postponed this month. Thank you. Mr. Sylvan.
Thank you, Chair Dr. Cass, on our board. Chris Sylvan, Albuquerque City Council. Updates go that the next City Council meeting will be February 23rd, and we're moving, well, I shouldn't say we, but the council has decided to move council meetings back to its original start time of 5 p.m. So make a note of that, because we've been starting at 3 o'clock because of the pandemic and the special emergency orders that we have. But we'll still be on Zoom, but we're going to start council meetings at 5 o'clock, and that's Wednesday, February 23rd. At the meeting, the CPOA ordinance will be heard, and can say that councilors who are sponsoring the changes and the amendments to the ordinance have taken what the board has inputted and blended it with what the councilors felt needed to be in there. Also taken comment from Executive Director McDormand and just folded in the best that they could, all the comments, and the councilors were appreciative of the boards and Director McDormand stepping up and saying what they felt was necessary in the ordinance. So look forward to seeing you on the 23rd at 5 p.m. With that, wait a minute, back up. We are still interviewing applicants for the board. We have completed our end of getting at least 2 applicants. I noticed that they're on the meeting here tonight. So their legislation will be heard at the council meeting on the 23rd, and we'll keep our fingers crossed that those applications should move forward. And stand for questions.
Are there any questions for Mr. Sylvan from the board?
Chair Cass, it appears that Ms. Gooch had a comment for Chris in the message, in the chat.
Chair Cass, board, yes, I saw Councilor Gooch's question, and the floor amendment, we'll do our best to provide that to the board beforehand, but with council rules and procedures, that floor amendments could just happen on the fly, so we don't know what's going to be in it until it's in it. That's the best answer I can give.
Any other comments regarding your report on City Council? If not, go ahead and give your public safety report, if you will.
All right, thank you, Chair Dr. Cass, Board. The Public Safety Committee has not met since the new council has been sworn in, but they will have their first meeting on February 15th, and that meeting will actually be at 3 o'clock, and it'll be on Zoom. The chair of the Public Safety Committee is Councilor Luis Sanchez. He's the new chair of the committee, and I don't have it in front of me in my notes, but who's going to be on the Public Safety Committee, but I will get that to you once we figure that out. And that's all I have for the Public Safety Committee report. Stand for questions.
Thank you. Are there any questions from the board?
I just wanted to say, Dr. Cass, I just want to say, Chris, I just appreciate you doing all you're doing to help get the vacancies filled. I know sometimes it feels like, you know, that you're the fall guy on some of these issues, but I just want to let you know that I know that's not the case and that you and the council services are doing the best you can. So I just want to say I appreciate all you're doing to get these vacancies filled.
Chair Cass, Board Member French, I appreciate that. Thank you.
Comments? Seeing none, we will move on to report from the mayor's office. Pastor David Walker, are you present? Or
Chair
is there
Cass,
someone?
if I may?
Yes, go ahead.
I did contact Pastor Walker earlier today. We usually touch base in advance of the meetings. Unfortunately, he's ill today. He won't be available, and so I did send a message to Ms. McDermott with regards to this matter.
Okay, thank you. We will move on then to city attorney's report, which probably puts you up again.
Yes, it would. Thank you. Well, as the board knows, the continuation of IMR 14 hearing occurred yesterday, and Ms. Galloway spoke on behalf of the board. It was a very good hearing. The city appreciated the comments from the amici, and it was a very meaningful hearing, I think. And so hopefully we can take some of those comments to heart and work to continue with the reform process. The other item of concern is that the superintendent search is ongoing. The national search remains. I can say that they are speaking with candidates, and I think that the process is moving along, and that I would imagine that we're pretty close to that. I don't want to comment too far along on that. I'm not sure exactly how far along we are on that matter, but I know that there are candidates, and it is making good progress.
I'm sorry, I didn't hear which search?
For the superintendent of reform.
All right, thank you.
Thank you, sir. And then Mr. Sylvan did speak to the status of the CPOA ordinance amendments with council being deferred. So I think that's all I have as far as the city attorney's report. I imagine that there are other items of concern that we'll be discussing later on in the agenda. If I'm not mistaken, we'll have an update probably on the MOU progress, unless you want to address that now. What I can say is we're having a follow-up meeting later in the week to follow up with APOA on their position on the proposed memorandum.
Okay, thank you. Are any questions for Mr. Pacheco from the board? Seeing no questions, thank you. And I'm sure we will be back in touch when we get to the MOU discussion in more detail. So,
Thank you, sir.
thank you. And so moving on to the report from the CPCs, Mr. Mensa.
Good evening, Chair Dr. Cass, and good evening, Honorable Board. It's good to be here. This being early in the year, our main focus for the last couple of weeks has been solidifying the CPC board, and finally we got that for 2022, or as long as everyone decides to last. We got new chairs in Southwest, Southeast, Northwest, Northeast, and Foothills, and also new co-chairs in each of those as well. We had a few people step down from chair to co-chairs, so they're not all new officers, but it is a large turnover. The only one in which we have the same officers from last year is in the Valley, where Rowan and Edwina are there. They don't really have anyone who's ready to take over now, so hopefully we can change that up at some point. We've also brought on a lot of new board members. In the Foothills in 2022, we brought on 2. We have 1 pending, awaiting an interview, and we got 9 total board members right now. The Northeast has no new members. There's 1 pending. That makes 10 total board members. We got 2 new ones in the Northwest and 3 pending, awaiting interview, and we have 9 total. We've got none in the Southeast. We got 4 pending people who want to go onto the board or else come back. One guy wants to come back to CPC service, and they've got 6 total at this point. Southwest has 1 new member, no pending, and 2 pending and 7 total. And the Valley has 2 new members and no pending and 7 total. So we've had 7 new board members. We have 11 people who are awaiting the opportunity to come onto the board possibly, and that makes a total of 48 right now of a possible 66. It's going to be hard to get fully staffed in every area command, but you know we got a pretty good number in each area right now. I introduced the Support One initiative in which we are trying to get. I sent out an email to everyone who attended a meeting last year who was assigned and received the notifications that, for instance, if you're in the Foothills, it's 1 city. So I want you to just go to 1 other meeting every month. In January, I highlighted the Valley meeting, and I sent that out to everyone with the agenda, and I told them what it was about, asked them to sign up. And in February, we highlighted the Northeast meeting, and both of them were good meetings. Northeast was a great meeting a couple of nights ago about the academy, what it takes to be a police officer, the pay, the time, and everything else, and was very well received. So we got a lot of new signups on that. People who are not from that particular area command who are going to watch anyway. So I think that's going pretty well. Diane Kinderwater contacted me about this. She wants to have me on Issues and Answers. I'm not really a TV guy, but you know, I told her I'd do it. And in March, we are trying to put together our council member training, in which we give everyone, because we have so many board members now, a new overview of what we need, of what we're looking for, and of what you can gain from the board. Now, and also a reminder from the people who've been there for a while, because there are differences in opinion as to what a CPC council member does and is supposed to do. So we're trying to get that together, and that's my report for this last 30 days. I'll stand for questions.
Any questions for Mr. Mensa from the board? It doesn't appear there are any questions for you, so thank you very much for your report. And,
thank you. Have a good evening.
thank you. So we are now at item G, CPOA report from Diane McDermott, the interim executive director. So Ms. McDermott.
Thank you, Chair Cass and board members. We opened 17 CPC since the date of the last meeting, which was 1/13/22. We received information on 13 driving complaints. Those come through basically 311, and those are then provided to the supervisors of the officers to address. And then we received 2 commendations since the date of the last meeting. The recommended discipline for the cases that you are hearing this month on CPC 191-21 involves SOP 2-60-45, sorry, 2-60-4A5F, sorry about that, verbal reprimand. And then CPC 202-21 involves two different SOPs, which is 1-1-5C3 and 2-40-3B1A III, and that's 3 CPC, sorry, SOPs, 2-17-2. And so for all of that, basically, it's a 40-hour suspension and a written reprimand. Something I wanted to bring to the board's attention that I found interesting during one of the FRB meetings is there was a new enhancement that was discussed with the computer-aided dispatch system. So you've heard of hazards being put on addresses. There is now the ability to put a hazard, if you will, or at least information on individuals. So if the officers have the benefit of knowing who they're dealing with, or if they obtain an ID and can run the information, they can potentially have more information about the individual that's going to aid them in potentially knowing how to de-escalate. One of the examples was an individual that sort of is a repeat person that the department has contact with. They have information on basically what the triggers are that cause force incidents to occur with this individual, and how to avoid them. So this type of information would be available to the officers dealing with an individual that they didn't have previously. So I thought that was something that the board would find very interesting. The investigator positions are filled. However, one of our investigators did have a start date delayed due to illness. The training is ongoing, so our two newest investigators do have some cases, but not a full load yet. And in discussing with HR about the variety of positions and things, the HR department encouraged that we do go ahead and reach out to the community engagement specialist applications that we had. So the names have been reviewed and those have been provided. Now, if none of those individuals or very few of those individuals are still interested, then we will have to go ahead and repost the position. I did want to mention something that had been from the previous meeting, which was Member Nixon had requested certain data to be provided. And that consisted of asking about new hires, cadets in the academy, cadets graduating the academy, termination, retirements, and resignations. So we did receive some information from Ms. Martinez of the DOJ that did have quite a bit of information and was a bit difficult to go through for some of the board members. So Mr. Abbasi, our data analyst, distilled the information down and presented a report. So the board has been able to hopefully review that. As was already mentioned, Chair Galloway and I both spoke at the supplemental court hearing for the amici and presented the letters and concerns to the court. The board did have the benefit from Councilor Gooch to have an overall summary. I did provide comments to the board in the form of the written report here, but just basically going over the intended plan to request a stipulated order to encourage for the mediation program again, the importance of having minimum funding, timeliness of investigations is directly related to staff availability and the impact that some of the delays of the HR process have caused for that, but that is being resolved and should improve. The board is hindered by doing its work because of the open positions. So the importance of filling the positions, filling them with good candidates. So just making the court aware of that. And then there was also the discussion about, by Chair Galloway, who initiated it, the modification of types of complaints. Of course, it is an issue for the agency as well. And if I understood correctly, and of course, Ms. Martinez can correct me if I'm incorrect on this, but that the DOJ wanted to contemplate the ordinance revisions before taking sort of a formal action or position on revising the CASA, which that type of an action would require. So those were the comments that were addressed to the court. A new APOA or collective bargaining agreement has been signed. I did provide some highlights as I saw them that were somewhat different in the CBA. There's a preliminary investigation timeline, which is allowed for up to 15 days. The investigation is to be concluded within 120 days. This is actually the same amount of time. It's just that the previous way was a 90-day with a 30-day extension. And now they just have it as 120 days with no extension. So that part hasn't changed in terms of actual time. The 40-day review period is now allowed by the chain up from 30. So they added 10 days there. A point that they made sure to clarify, or that they put in this particular new collective bargaining agreement, is that any additional allegations that arise out of the investigation, those have to be considered and contained within the original 120 days. If I understood correctly, there have been occasions when something new has arisen, and these were pretty rare and pretty dramatic, but that they may open a different case and therefore new timelines. But this new agreement has kind of clearly delineated that out. The final notice of determination to an officer is going to be sent within 20 days. And I believe the original was 14. So there's been a little bit of an extension there. If an investigation is completed out of time, there is no discipline that will take place. That's nothing new, that has happened before, and it will not be used for regressive discipline. But one thing that was interesting to me, I don't think it said this in any of the previous ones, that retraining, policy recommendations, promotion considerations, or aggravating circumstance consideration would still be possible for these types of cases. So that's beneficial. During the court hearing, I did find it interesting that the APOA seemed reluctant to sort of define this as a newly signed CBA, but based on the information, this is a new CBA. They have renewed their agreement. Much of it, like I say, is the same, but there are a few changes. There was a bit of an assertion that timelines have been extended. I would argue the investigative timelines really haven't been extended. So just something to be aware of. It was shared with the board. Final couple of things. The monitoring period concluded on January 31st. If there's anything outstanding that I need to be aware of, such as training documentation, please get that to me. Members Cass, Cass, Galloway, and Nixon did provide me their annual trainings, which I did provide to the monitor already. And members French and Crawford did not have any annual trainings due during this monitoring period. But if there is anything else that you need shared, you want to share, please let me know, and we'll make sure that the monitoring chain gets that. Chair Galloway and I will be meeting with prospective board members that have been provided by Mr. Sylvan. As you already know, a couple of them are observing our meeting today. And then I did forget to write this in the report, but there needs to be a change in the meeting date in May. It is going to be the 19th because there is a conflict with GovTV and the council. So it will change to the 19th. I think the previous date was the 12th. And I think that's it.
Are there any questions for Director McDermott from the board? Member
I have
French?
one question. Who are our visitors that are may be coming on the board?
Oh, I'm sorry, you may have missed that. So Amanda Chino Zamora, and I believe it's Michael. Yes, Michael Wartel are the two names. And we have a third name, but he was apparently unable to attend tonight's meeting to observe. But both of these individuals have been forwarded by Mr. Sylvan as potential board members. And I will say there was some confusion, I think, with Mr. Williams having observed a meeting. I think a couple of citizens thought that they were already board members. These two individuals are not board members yet. They are just proposed as potential to be taken up by council. So they are getting the observation period out of the way, if you will, now, and being able to assess if this is the right fit for them and get that portion of the necessary observation out.
Thank you.
Any other questions from the board? I have one, and that is what is the only consequence of not meeting a deadline as far as the collective bargaining agreement is concerned, the inability to impose discipline.
Yeah, as far as I know, that is the primary reason. So if you are out of timelines, then you would not be able to enact discipline. But as I read this CBA, other things can still be considered, such as policy revisions, which of course have no, disciplinary action against officers or employees, I should say. So that's the main consequence of being out of time. Is no discipline, and of course in other areas, just what am I trying to say? Just to have the community know what's going on with stuff, obviously is not good either if it takes too long. So.
Okay, thank you. That was my understanding as well. So that's consistent with what I thought I knew. So thanks.
Dr. Cass, I have one more question. Diane, I just want to
Yes, go
say
ahead.
thank you for the excellent report, but I appreciate you giving us a total of how many new cases you're getting each month, but I would also like to include it in your report how many that are being cleared each month.
Well, the cleared, so you're seeing, I'm sorry, not to interrupt you, but the ones that you're seeing, of course, that are completed, the board is reviewing. Now there is the lag time because the board does need to have the upload period. So there's basically a 2-week time frame that you're getting roughly from the last meeting to the upload period of time. So more cases do get completed for the month, but your cases that you are reviewing, you can kind of see what's being closed between the last meeting and when the upload period occurs, if that makes sense.
It does, but I'd still like to see a number of how many got closed per month. I just think it's beneficial for us to see and for the public to see the investigators and how hard they're working, the cases they're clearing. So I would just the total number would really be appreciated.
Sure.
Okay, thank you.
Any other questions from the board? Right, seeing none, we will move on. Thank you for your report. This is a very detailed report. I think it's very illuminating. So I thank you again for it. Appreciate it. I suspect there was a lot of effort put into it, and I know you've been really busy given the other duties you have, interim director, and a lot of other things going on. So thank you again. So we are at item 7, non-concurrence cases. And let me just say a few words in introduction to this. These are cases which the agency has sent their findings to the chief, which involve discipline typically. And the chief is obligated, or his designee in this case, and I believe it actually has been changed to the superintendent, takes over that report. But the superintendent or his designee is obligated to respond to cases which have been investigated and findings made by the CPOA where they do not agree with the findings. And so what we have, there's been some bit of a backlog of these. We have not received a number of these for some time, and we received 5 this month. And Director McDermott tells me that there's a number more that have been, waiting for us for next month. So the results of this, the letters are posted to the website on the CPOA website, and the link is fairly easy to find, and I can, so are made publicly available. But I think it's worthwhile to at least review what the cases were briefly, so that we can get a perspective about what the chief's response or the superintendent's response to this was. So the first case was CPC 3821. Where APD found an allegation unfounded and the CPOA found the allegation not sustained. And the case involved an officer was asked if he allowed operator G to drive while she was under the influence of alcohol per the complaint. His response was he did not believe that she was, and Rio Rancho Police Department felt she could drive as well. So there was an issue about whether the investigator officer had fulfilled his duty by preventing somebody from driving where there was a suspicion of alcohol involved, and the rationale for non-concurrence that, from the superintendent, it says I concur with the recommendation provided by the commander as follows: based on the evidence presented and the fact that the complainant did not cooperate with this investigation, I do not concur with the CPOA's finding of sustained nor the recommended preliminary discipline calculation. I recommend this violation be not sustained. Per the Civilian Police Oversight Agency finds the executive director recommends a class 6 sanction to be added to this SOP violation. The subject of this investigation allowed his personal animosity toward the complainant to affect his judgment. He chose to take enforcement actions against the complainant, issue a summons, while others committing similar offenses were not summoned. This action appears retaliatory. There was not enough evidence to prove a violation occurred of the department's retaliation policy because the complainant did not cooperate with the investigation. So that's
Cass?
kind of, yes.
Since
Attorney
the
French.
agency is the one that made the recommendation and the non-concurrence is on the agency's recommendation, I would like to hear from the agency on their response to these non-concurrence, because it's my understanding the agency doesn't agree. Diane, could you walk me through that process? How does that work?
Well, one thing I wanted to clarify first off, Dr. Cass, Chair Cass, you were reading CPC 3821, is that correct? Okay. Yeah, I think you blended a couple of cases there because you were talking about one and then the facts started blending into a different case. So just for that, there's a little bit of confusion there. So Member French, to your question about, hearing from the agency. So I know Chair Cass and I had talked very briefly before the start of this meeting, and unfortunately I didn't pull all these cases to be super prepared to talk about them. But what I can sort of go over is going back to the 38-21. As Chair Cass had said, there was this issue of whether or not an officer allowed an operator to basically drive under the influence, and APD's finding was an unfounded versus our allegation was a not sustained. So basically we're saying that we really couldn't establish, we didn't have enough preponderance of the evidence to say one way or the other. And the concern that I have is that APD is saying that it's unfounded, which means there is clear and convincing evidence that the officer didn't do this, basically. And in looking at the evidence and looking at the case, the officer basically said, he didn't remember a reason why she'd be unable to drive. There were some liquor bottles, but there was apparently a reason for that, some kind of a previous party or something. The department said in their review that they felt there was no way to know for sure that the investigation completely ruled it out, but it wasn't on the officer's burden to figure that out. So our issue is just that we just do not think that there is clear and convincing evidence to say that this is unfounded. That's why we would still maintain that the proper finding would be not sustained, but that is the difference of opinion, and for the board to just take under advisement, I guess, on that particular SOP. And then the other SOP being 1-4J, again, APD decided to change the finding to unfounded. We again said not sustained. The issue being, did the operator consume alcohol on the same day that they basically were going to shift? When the investigator asked the questions, the operator basically did not recall for sure if they had had alcohol during lunch, basically. So again, whether or not there was enough evidence to say for sure, clear and convincing that absolutely that wasn't true, the agency, the investigator, didn't feel that there was a substantial enough evidence to say that standard. So that was where we were coming from on that particular case.
So you can obviously do a much better job at presenting both sides of this case than I.
I'll try.
I think this was a good, this is a segue. I appreciate Member French asking this question, because that sort of gets me off the hook, but it kind of puts the pressure on you. So if you want to continue this explanation, I think you can provide better background than I, but I think it's a worthwhile discussion to have. And or is aware, because as I mentioned, it's been a long time since we've actually gotten these, and I think it's an important part of the investigation of the CPOA's investigative process, is that we get that, given that we are in a sort of a recommendation role, when our recommendations aren't followed, it's been made known that we should get more than just a checkbox response that said we disagree. So
Yes,
yeah,
thank
so
you, Diane.
go
I want
ahead
to hear
with-
the agency's point of view.
yes. So thank you. So Director McDermott, if you could continue, I'd appreciate it.
Did you want me to go on to the next case, or was there anything?
Yes,
further?
please.
Okay. So in CPC 93-21, so the finding of the 1-1-4D14, our agency, our investigator found that the allegation was sustained, that the APD found that it was not sustained. And the issue with that, at least that as I'm presenting it or understand it, so APD's rationale for finding not sustained, as you read in the letter, they described that the sergeant exercised discretion and constraint by not engaging with the complainant. While on the scene, the complainant harassed and distracted the sergeant, gave the individual direction that the individual refused. All of that occurred, and that is accurate on the first incident. There was 2 incidents that the citizen filed a complaint about, basically, that were connected, so to a degree connected. So on that first incident, the CPOA investigator found and agreed that the sergeant did in fact exercise great constraint and discretion by not engaging with the complainant or issuing any kind of a summons or anything like that. The problem comes, as we see it, with the second date, the second incident, which occurred about 2 months later, almost 3 months later, when the sergeant did in fact issue a summons against the complainant, because that incident, the sergeant did not actually talk to the complainant, did not say anything, they did not engage in anything, and yet they were summoned at that time for violating the public health order, which was not wearing a mask. The sergeant had actually interacted with 2 other individuals that were there that were not wearing a mask also, and they did not receive summons for the public health order. So there did seem to be this discrepancy of this individual that the sergeant is aware of and has had some negative interactions with in the past issues a summons without even talking to that particular individual, and yet 2 other individuals at the very same scene with the very same quote unquote infraction, he did not issue any summons to. So that is why we felt that this conduct was sustained, and I can't say why the APD decided to go not sustained, because other than they were focusing on the first incident as opposed to, I feel, instead of realizing the second incident.
Questions, or shall we continue?
I'll save my question until the end, Diane, because it's just about the process, etc.
Okay. So the next one being 109-21, the SOP issue there. So 1-1-6A3 actually is the same SOP as 1-1-4D20. The difference being is APD does sometimes, out of various reasons and necessities, change SOP numbers. And so one of the challenges, of course, for investigators is that we do have to use the policy that was in effect at the time, not the currently published policy. So at the time that this incident occurred, the proper policy was the 1-1-4D20, but has since changed the number. So it looks like it's completely separate, but it's really just the same thing and a change in numbers. However, the allegation that the investigator found was that it was sustained. And again, APD found that this was not sustained. This complaint arose from basically a judicial officer who had determined that the detective did not act in good faith during an evidentiary hearing and was not credible. And basically the detective admitted he failed to disclose promises made to a witness in a case. And so, based on that finding of the court, it was deemed, and some of the other work that the investigator had done, it was deemed that that should be a sustained finding, but APD decided that it was a better as not sustained. So that's the issue with that one. For 249-20, again, the SOP being 1-1-4D15, the investigator found that it should be sustained, and APD found that the allegation should be administratively closed. The officer brought up the complainant's past and said he had reason to be scared of him. When the complainant asked why he was being detained, the officer told him for reasonable suspicion, made some what we would characterize as a kind of a dig on their intelligence by saying, that's a 3-syllable word, so it'd be hard for that complainant to understand. The departmental review acknowledged that there were bits and pieces of the conversation that, should have been left out. But to them, calling the complainant's intelligence into question didn't rise to the violation. I'm, of course, characterizing as I'm reading it. You can read the letter of what they actually said. In their mind, though, in the department's mind, since the policy was minor and not a significant pattern of misconduct, the department recommended the administratively closing. So there you go. That's what they have to say about it, but we disagree. And then the final one being 250-20, which is 23-52 for F1A. The CPOA found it being exonerated, and APD wanted to change it to unfounded. So the allegation was that the officer was squeezing the complainant's fingers tightly while being handcuffed. And the officer explained that the fingers are held during the interviewing process, that the fingers are held while conducting a pat down, but basically denied squeezing them. So the lapel video showed that the officer was in fact holding the complainant's fingers. The video showed that the complainant said something about being squeezed, and that the officer said she would if she felt the complainant was wiggling around. And then the investigator observed that the officer shook the complainant's hands. So the physical interaction occurred. It was not as the complainant described or alleged. So that's why we went with exonerated, though, that it wasn't a violation of policy. It occurred, but it did fall within policy, versus the unfounded, again, would indicate a clear and convincing that it didn't occur at all. So that's why we disagree with that. So, and I think that's all of them.
I have a question, Dr. Cass.
Yes, go ahead.
So Diane, thank you for that review. I really appreciate it. So I see the difference of opinion in your investigators and APD and their decision. Could you explain to me the process for these non-concurrence? Do they go to you, then APD? Do they go to APD and then to you? Where do they come from? Do you give them to APD or I give them to you? Could you explain the process to me on exactly how these non-concurrence happen?
Sure. So we complete our investigation, and the investigation goes for basically 2 avenues of review. It goes to the board, of course, and you review the findings. And then it also is sent to the chain of command. So it's sent initially to internal affairs, and then internal affairs forwards the investigation to the particular officer's supervisor, the commander level. And then it goes through, depending on what the recommendation is and what if there's any discipline, that type of thing. It may not get as high as the chief. It goes sometimes just the commander and a deputy chief kind of thing. So it does depend a little bit on what's going on with the case. But in general, it is reviewed by the chain, let's just put it that way. And then once the chain reviews it, and if they have a non-concurrence, meaning that we have either a difference of opinion of what the findings should be or the discipline level that we have recommended, then that is given back to us here at the agency. And then I look at that and say, okay, this is a non-concurrence. And then that non-concurrence is presented to you here in this form.
So who gives them back to you? You said they come back to you.
They come back through IA. So they come from the chain of command back eventually to internal affairs. And then internal affairs, we pick up cases from then to do the final closeout and the final reviews and everything like that. So we receive them back from internal affairs, and they should, and this is a process that we are now finally getting to, I think, a process that's going to be a little smoother here on out. There was some confusion on, I think, the department's end on a few of these and where they're going and what's happening. The superintendent process was newer. And so I think we're getting to a more streamlined issue, but yes, we'll get them back from internal affairs. If there is a non-concurrence, the superintendent is to be aware of that and writes these memos as you're seeing now. There's a sort of established form so that hopefully there won't be missed opportunities for explaining, to the board as it's required. So we get them back from internal affairs. I take a look at them, like these ones that I got back. I wanted the board to understand and sort of review, take my take on it. And I mean, there are going to be times when it is just strictly a difference of opinion. There are times when I may, as the director or the investigator or whatever, may feel that I am more right, I guess, if you want to call it that. But, it is what it is. And, we have the dialogue, and then we present it to the board so that you have the information as well to know what the department's thinking. We take these into consideration because there are times when maybe we didn't think of something or we didn't see it that way or whatever. And we as investigators learn from that. And then, you as a board, of course, discussing it can potentially, convey if there's something that you want to convey to the department, basically, in your discussion of these. So that's where it's at.
So if we don't agree with the non-concurrence, we also can send something back saying, due to these facts, we don't agree with the non-concurrence, or it's a moot point at this time?
I mean, it is. I'm sure there is always the way that if the board so chose to write some sort of a letter saying, we still uphold or think that the agency had the right call, or we disagree with the non-concurrence or something. I'm sure that the board can obviously write that to the department, but as to what would go from there, I don't think it, they can still maintain their finding. There isn't any mechanism to force them to change it. So.
Okay, thank you, Dr. Cass.
Yes, thank you both for, I think that was a good discussion. I think that, I'd just like to say, in my view, at some point, when you get back the non-concurrence letter, that for us to reinforce our position without having any possible change resulting from that, seemed like it would be somewhat futile. I mean, we already have gone on record. We've approved the original investigation findings. We essentially agreed with the investigation. And when that's sent over and we get a non-concurrence back, well, that's our answer, I guess. But subsequent action on our part it seems to me it would be futile. It would just be a restatement of what we'd originally originally said. And so I think it's available, but I would think that we would have better things to do with our time than to do that. So, but the board can always decide that they want to take an action like that. And I think Director McDermott pointed that out. So thank you.
And if I may, I
So
just wanted to add, I'm sorry, Dr.
Go
Kess,
ahead.
I just wanted to
Go
add real quick that, as I said, this is important information for both the board and the agency to consider, because there are some pieces of information that we may learn from that. So, that's certainly why the situation is laid out as it is. So even though there may not be an actual change that would occur if the board chose to, I think it's just important that the discussion occurs, that the board hears it, and that we as the agency hear it and receive it. So just wanted to say that.
Okay, so if there any other board members have questions or comments that they'd like to make at this time. If not, we can move on to item 8, the CAO review update, which was I believe a request for information that was made earlier, and we received this was a response by the CAO of the city, Sarita Nair, in response, who's, I believe, the appropriate, certainly the appropriate and only person who can respond in matters related to the chief. And so that's why this is it's essentially a non-concurrence letter that comes from that level, because it's about, because the complaint was about the chief. And I think it's worth, again, highlighting that. And I think just to read it for the record, first of all, the complaint came from Charles Harrison. He submitted a complaint by email in which he alleges Deontay Williams was charged unjustly for child endangerment by Detective G under unjust orders from Chief M. Additional complaints were received in regards to this and included treatment of subordinates. And the response, the findings of the agency were that the information reviewed showed clear and convincing evidence an unlawful order was not given by Chief M. The information reviewed determined by a preponderance of the evidence that Chief M did have a meeting with staff members on April 14th, 2021, and through his conduct violated policy by failing to convey a sense of pride and professionalism to subordinates. So that's the investigator findings. The non-concurrence response, I will read. It's addressed to Director McDermott. I received CPC case 122-21 for review because the allegations of this case are against Albuquerque Police Chief HM. The investigator recommends finding that Chief HM violated APD standard operating procedure SOP 3-14-4A8 and imposing a verbal reprimand. This SOP requires, quote, all supervisors, regardless of the level of supervision, will and professionalism to all subordinates. The conduct in question involves a meeting in which Chief M is discussing issues related to a protest on Civic Plaza involving emergency response team officers. The meeting was with officers who had quit the ERT. In particular, the investigation found that the policy violation arose from Chief M stating that he did not care if officers quit the ERT. I reviewed the full SOP 314 and the full recording of the incident in question. To summarize, there were 2 statements that appear relevant. After reviewing recent ERT incidents, Chief M apologized for difficulties in communication during the height of ERT incidents, but suggests that quitting was not a helpful response to those difficulties. He stated, quote, we'll survive. I think we are letting down fellow officers. And like I said, I'm not here. Everybody quit. That's fine. We will be dispatching field officers, unquote. When heard as part of the totality of the conversation, it appears that Chief M was explaining that the impact of ERT members quitting the team was that emergency response would be carried out by field officers. It does not appear that he was encouraging officers to quit or minimizing the impact of their quitting. It was the opposite. He went on to explain the new policy of training all new cadets in ERT operations so that field operations would not be compromised by ERT deployments. Later, Chief M stated, I said I wasn't here to ask anybody not to quit, but I hope everybody in here realizes the consequences and that we're a team. He went on to express his support for officers, saying, I won't quit on this team. Chief M went on to take questions from ERT members who had resigned and to address each of their concerns directly. Although some of these questions were not framed in a respectful manner, Chief M responses were respectful. At the end of the recording, Chief M stated, thank you again for your service while you did it. We'll figure it out. SOP 3-14-2 states, leadership is a critical aspect of constitutional policing. Indeed, leadership is the key component of an effectively run organization. The chief and command staff set the tone, provide the vision, and instill motivation for all subordinates. They provide the department with overall leadership and a view of the future. They establish appropriate goals and objectives for a professional, highly and well-run police department. The tenor and tone set by the chief and command staff provide the framework for achieving success. While I understand the investigators' concerns, I do not concur with the proposed finding. When viewed in full context, it appears that Chief M was trying to deal with a difficult management situation and trying to illustrate to his employees the consequences of their actions. By speaking to these officers firmly and directly and creating space for them to express their concerns, I find that Chief M was following both the spirit and letter of SOP 3-14. Although discipline is not warranted in this case, I have discussed this incident at length with Chief M. Thank you for the CPOA's diligent review of this case, and please let me know if you have any questions. And this is signed by Sarita Niner. So that's the letter we received, or the agency received yesterday. So if there are any comments, questions by the board. Hearing none, we will move on to item 9, which is requests for reconsideration. And we have 2 cases where there are requests for reconsideration. One is the CPC 134-21, and the second is 135-21. So we'll consider 134-21 first. And so I would ask Council Gooch to read us our normal process for having a request for consideration, if you would, please.
Thank you, Chair Dr. Cass. There are 3 criteria that the board should consider. First is whether a policy was misapplied in the evaluation of the complaint, i.e. the APD policy or policies that were considered by the board were the wrong policies or they were used in the wrong way. 2, the findings or recommendations were arbitrary, capricious, or constituted an abuse of discretion, i.e. the APD policies or policy considered by the board were chosen randomly. They do not address the issues in the complaint, or the findings of the board had no explanation that would lead to the conclusion made by the board. Or finally, the 3rd criteria, the findings and recommendations were not consistent with the record evidence, i.e. the findings were not supported by the evidence that was available to the board at the time of the investigation.
Thank you. So I will, before we launch into discussion, I think it's appropriate to read what the original complaint was. And this complaint comes from Charles Arison, and it reads, you filed a complaint. This is a summary by the agency of the original complaint. So it's not Mr. Arison's words directly, but this is a paraphrasing of his complaint. You filed a complaint against APD. Mr. G blocked your access to his Twitter social media account that he uses for his official department business. On 6/8/2021, Mr. G posted a tweet saying, I hear some trolls are butthurt because I blocked them. They're trolls, nothing to see here. You stated, to be clear, my reporting has been showcased in all 3 local TV outlets, in local newspapers and local blogs, and gone viral across worldwide accessible social media outlets. Far from trolling or nothing to see here, Mr. G's blocking anyone's access to any of his official social media accounts can only be recognized as retaliation. I believe Mr. G's actions violate but are not limited to APD SOPs concerning conduct, social media usage, and retaliation. The findings of the agency, there was an unfounded finding, a sustained finding, and a not sustained finding. And I'll go through those. I won't read, well, the policy in general deals with, first of all, SOP 1-1, which is, has to do with officer conduct. In this policy, it is sustained due to the Twitter evidence and photos showing Mr. G blended his personal account with APD related materials. Because of the blending, this has caused public confusion. Mr. G became a government actor. He then blocked Mr. Arison from the account, which he is unable to do so. Tweets obtained also show Mr. G was using terms such as trolls, butthurt on the account, which is a violation of general conduct. The second issue, which was unfounded, dealt with SOP 1-2-5N and regarding Mr. G's personal Twitter account being linked to the city email. There was no evidence found that would link the two. Over 2,228 city emails, including duplicates from 3/1/2021 to 9/1/2021, were retrieved and reviewed. There were 0 Twitter notifications linking Mr. G's account to his personal Twitter account. The third issue was 1-2-5F and 1-1-7A are not sustained. On August 2020, the August 2020 tweet pertaining to a shooting was already dealt with from the previous police chief, and there was no specific person or persons that could be identified that were tied to the allegation of lowered morale. The original transcript was never provided by the journalist to compare whether or not Mr. G's out-of-line comment was ever taken out of context. So that's summary of the complaint and the findings. We have so the question is, has there been any of the 3 criteria satisfied that Ms. Gooch just read that would suggest that this complaint should be considered? One other piece of information which I would like to bring up at this time involves a policy recommendation that has been discussed at our Policy and Procedure Committee, and Member Crawford, I'm sure can tell us more about this than I can. And so, if you would, Member Crawford, I'd appreciate a brief explanation of what you found as a result of your inquiry into this social media issue.
Definitely, thank you, and hopefully you can all hear me now. One of the kind of major issues that came out of the investigation of this complaint was basically that APD has very little in the way of policy in the area of social media. I think it's often, kind of recognized that personal accounts that are in this kind of between a personal account and an official account are poor practice, but there was no policy prohibiting that. The investigator in this case actually originated a policy recommendation that APD develop a social media policy that, among other things, would prohibit personal accounts which are sharing department material, using department logos or identity, just otherwise creating the appearance that there's some kind of official channel. We have not yet formally issued that policy recommendation because it's sort of attached to another policy issue that came out of a different but kind of related question. And it's just taken a little while to sort of develop the final version of that policy recommendation. But I do think that the policy recommendation to create a social media policy should move forward. And my inclination is probably to try to have it before the board next month. Even if we haven't gotten there on the other related issue, we could just issue the 2 separately so that this one doesn't get dragged out too long, because I do think it would be a really valuable issue for APD to address. And I think I've seen maybe 3 complaints that were all kind of related to the same area. So I think it'll be a helpful policy
thank you, Member Crawford. So I'm trying to find the additional information that was presented by the complainant, and I'm at a loss to find what was sent is in terms of to justify this reconsideration. That
Pass. I do have that in front of me. I could read that if it's easier.
Would you
Do we
please?
need to read that in order to vote?
I would say that we should
Sorry,
have that information. And that allows us to consider whether this meets the standard of reconsideration. That
I will say the request for reconsideration is very short too, so it won't take up a lot of time. Mr. Arison said, being that the audio recordings, the CPC findings letter makes no mention of the illegal destruction of a public record, being that the audio recordings of my interviews with the CPOA investigator clearly show there may have been criminal conduct by APD personnel, destruction of a public record in this case, I contend that the investigation, policy was misapplied. He just lists the criteria, but that's basically the meat of the request is the destruction of records issue.
Thank you. So with that information, the question before the board, I believe, is: does this constitute new information that would allow us to grant or cause us to grant a reconsideration of this case? So if I'm inviting any discussion around this subject, if there's no discussion, we will have a vote on reconsideration. Yes, Director McDermott.
So just for the board's information, I was taking a quick look at the summation of the interview, and I don't believe that particular issue was raised in this particular case. Mr. Arison does have a few different complaints about a few different issues, so I'm not sure if he's blending complaints, but in reviewing this particular summation, I don't see that was specifically raised. And then there is kind of the additional thing to consider of whether or not the information he's alleging is in fact, first off, considered a public record. Because if it is, that's one thing, but if it's not, then there would be no quote unquote illegal destruction. So that's just something to be aware of when you're discussing things.
Member French.
Member Crawford, could you address what she just said? And you know, we all read the complaint and we know who he's complaining about. And, you know, that took me back a step too, because of the person's position with APD. So I have not come to a conclusion, but I would, you know, since you did investigate this or review it a little more, would you address what Acting Director McDermott said? In your
sure,
view,
yeah, I don't know.
In your view.
I don't know that I have a lot more to say. I'm kind of in the same position. If I looked at the complaint and I've kind of been skimming through the investigation report, and I'm not completely sure that I know what the destruction of illegal records is referring to in this incident. I kind of remember seeing something like that, I think, in another complaint from the same individual. So I'm actually wondering if maybe it's just a bit of a mix-up where maybe that was actually something that we handled in another incident. So I'm not totally sure exactly what the request for reconsideration is getting at there.
I did read it, and that's my question too, is what Diane said, was just because this individual was an employee of APD, is his Twitter account actually public information? Or was he, or was it putting out there as he was publishing information reference APD, and this was more of advertising, or I shouldn't say advertising, but newsworthy Twitter concerning APD. So, that kind of was my question also on this, because, I know working at APD, if you use your telephone and you do anything that is work related, your personal phone, they can IPRA your personal phone, your text and everything else, because it happened to a supervisor. So I'm not sure. That kind of makes me wonder if he did use this Twitter account for official APD information, then does it become a official account and he can't block people? So there's a lot of questions for me here that I really didn't get it in the investigation, other than, as Diane said, they can't prove that it was not just a personal Twitter account. So I'm kind of not sure. And Diane, was there any further investigation done that states
So
specifically whether it was a person, it is a personal account and not subject to IPRAs or saying it's destroying a public record?
So there's two kind of questions that are in that discussion there. So, first off, the issue of the record stuff wasn't really raised in this one. He does have a different complaint that more clearly addresses that issue. But a couple of definitions that might be helpful for the board out of state statute, basically. There are things considered non-record, which are basically defined as extra copies of documents that are kept solely for the convenience of reference, stocks of publications, transitory records, records not usually included within the scope of the official records of an agency of a government or government entity, library material intended for reference or exhibition. Following examples are materials neither made nor received in pursuance of statutory requirements, not in connection with functional responsibility of the officer or agency, extra copies of official records, preliminary drafts, blank forms, transmittal letters or forms that do not add information, sample letters, reading of files, things like that. So that's a definition of non-record, which means that if it was deemed that, it would not actually fall under the retention, necessity. And all of this I'm saying is sort of with caveats. It depends. There are some specifics. There have some, you'd have to actually ask in a legal opinion, but I'm just kind of giving you some definitions that might be helpful. Transitory, as defined, means messages which serve to convey information of temporary importance in lieu of oral communication. Transitory messages are only required for a limited time to ensure the completion of a routine action, preparation of a subsequent record. Transitory messages are not required to control, support, or document the operations of government. So those are a couple of the things that things like Twitter, things like text, things like social media stuff can fall in these. There are times in which they are considered records. For the purpose of this, though, in terms of the blending of accounts, so much of what this individual posted on his page was essentially retweets that were on the official page of APD. Where the issue came was that there was some interaction, the blending, like we said, where there was some confusion of, yes, we've got this information posted on this page that was a retweet from the official page, but because the employee would say something like, I am, so indicating that they are, an APD employee. So there's that blending issue, which is why we sustain that particular issue. But does that make it an official public record? Not necessarily. Again, it would depend. I can't provide you with an exact right now, but that's based on what I understand in conversations with the city clerk and in conversations with reading some of the materials, is that there is, there are these definitions that much of that material would fall probably in one of those either transitory or non-record, therefore no illegal destruction of a public record. The page contained, as far as I understand, mostly retweet material. I'm sure there could be an original piece perhaps on there. I don't know for 100%. Neither does the complainant, because they were blocked. I don't believe that was their main allegation in this particular complaint, was that they were blocked. And as we agreed, as we sustained the employee, that they should not have been blocked from that page because of the blending of account, because of the confusion. So this
Ryan,
issue of the record.
What did you just read? Well, I'm very interested when you said if he posted official business on this, and that's different. Where is that in the IPRA laws, or where did you just get that information?
That was the Central General Government Administration Functional Records Retention and Disposition Schedule, Title 1, Chapter 21, Part 2.
Okay. And let me ask you another thing. If he posted official APD business on this website, on this tweet account, at that time, I mean, the official business. So that causes me to think, yeah, the average person would think.
If it's a repeat though, that's the only thing. If it, like, as it says, extra copies, quote unquote.
And what is the city clerk saying about this? Because I think this falls under IPRA, if I'm not mistaken. What did the city clerk say?
Right, that was just, this was some of the reference material. Let's see here. I have a little bit more. Basically just in his opinion, and again, he is not providing a legal opinion. He is not saying that this is absolutely one way or the other. These are just more conversations so that we would have a better understanding. But you know, in reviewing the information, statutes that have been referred to generally only applies from the complainant, only reply to things that would have to be kept, like medical records or medical assistance cards, things like that. To the clerk's knowledge, that their public employers are not required to create personal pages. He's not aware of a case involving personal accounts. He does not think it's likely that the actions if described would qualify as some sort of a, you know, violation of law. But again, I'm saying this very strongly with a caveat. There's been no official legal opinion on any of this. This is just sort of information research to aid the board to like kind of decide what they want to do with this.
So did you reach out to Ms. Gooch since you said we didn't have a legal opinion on this?
I have not inquired for Counselor Gooch to make a legal opinion on this, because at this time, it is more whether or not the board wishes to grant the reconsideration and whether or not it falls under those three conditions. If there is something that occurs to where that legal opinion is actually necessary, then, you know, Counselor Gooch would be asked to provide that. But at this time, no, there's not been that need yet.
Okay.
Thank you. So I'd like to make a comment. I think that's already been pointed out, and that is that the original complaint did not suggest any illegality in this, which was brought up as kind of a new complaint. And I mean, I'm not sure what is it was regarding a destruction of public records. That was not part of the original complaint. It had to do with his being blocked from the social media. So it seems to me that if I'm leaning against granting reconsideration, because I think he can file a new complaint regarding destruction of public records, which is a separate complaint from what he did originally. So it seems to me that for the purpose of this particular complaint, it's been dealt with. And in fact, he got an answer, which was that one of his points was sustained by the investigation. The other two were either unfounded or not sustained. So it seems that at this point, that this case has been dealt with partly to his satisfaction. And if there's a new issue that he's bringing up, that can be filed in a new complaint. So is there any further discussion about this before we vote on whether to reconsider
Chair Cass, you haven't made a motion yet, just an FYI.
So
you need to
do I
make
have
a
a
motion.
do I have a motion to reconsider?
I was going to
122?
move not to reconsider this case. I think largely for the reasons that have been articulated, and also just because honestly I don't know that there's much the board can do about that issue. You know, I think if Mr. Arison feels that there was something like an IPRA violation, then that's not exactly our wheelhouse. So we don't have a lot of way on that issue, I guess.
I'd like to offer a friendly amendment to phrase the motion in a positive way, that we to accept, and then if we vote it, then the vote will determine how that goes.
You know, the only reason I didn't do that, and maybe Council Gooch will have an opinion on this, there's been some confusion in the past with how the board voted on reconsideration decisions involving the same individual. So I want to do it in whatever way will make it most clear what the outcome is. And I'm a little worried that if we move to reconsider and then don't vote for the motion, then it'll open a question about whether or not it was settled.
Chair Dr. Cass, Member Crawford, I agree. I think that the motion as presented by Member Crawford is the most clear, but I defer to the board as to how anyone might want to second the motion.
I will second the motion as presented by Member Crawford. So is there any further discussion on this case?
I'm just not clear what the motion is. If it could be stated one more time, just for clarity, I think we'll be okay.
Member Crawford, would you restate your motion, please?
That is the downside to wording it this way. The motion is to not reconsider this case.
Thank you.
Seeing no further discussion, Ms. Varela, would you call the roll, please?
Member Crawford,
Yes.
Member French,
No, and I feel like if there's any doubt in our decision, if we have any, we need a legal opinion, et cetera, we deserve it to the citizen to grant that appeal for more information. So my vote is no.
Member Dr. Cass,
Yes.
Member Nixon,
Yes.
that motion passed on a vote of 3-1. Thank you.
All right, moving on to case, we're now at 9B, case 135-21. And I will, this is another request for reconsideration. And so I will, I don't know if we have anyone present to make this, to lead this, discussion or to make their case, but read the original case complaint. And this regards Antoinette Bodman filed a report and said a firearm was pulled on her on August 7th, 2020, and the police did nothing about it. Bodman and her friend Robert Cancino initially went to inspect the property being rented by April Vincula Lucera. Cancino is her landlord. An argument ensued and Kent ended aiming and cocking a weapon during the argument. The cops were called, and when they got there, they were instructed to wait for Sergeant L. It was later discovered that Sergeant L and April Vincula Sarah are alleged sisters. That is why nothing was done about Bodman's life being threatened. So we received I think a fairly lengthy email from the complainant regarding the evidence that was presented that she would like to present to have this reconsidered. And so the board has had a chance to look at that evidence. And so if we have a motion to reconsider this case. Director McDermott.
Just as a point of clarification, Chair Cass, you had said something about if there was anyone wishing to speak at this time, just so that, you know, for clarity's sake, for those watching, when there's the request for reconsideration, the individuals do not appear before the board. You take upon the information, and then if a hearing is granted, that's when they would appear. But I just wanted to make it clear that individuals don't appear during this portion of your discussion. So.
Thank you. My mistake. Thank you.
I'm going to make a motion not to grant the appeal on this particular case.
I'll second that. Is there any discussion from the board? Any just, I want to make sure we don't just skip through this without having board members give a chance to weigh in. So if there's, I'm looking for, there is no discussion. There's no further discussion about this case. So Ms. Morella, will you call the roll?
I'll just comment briefly. If
Member
nothing else,
Crawford,
just so, yeah, if nothing else, just so maybe, you know, the television audience has a little context. I read through the request for reconsideration. It's a little tricky to read, and I honestly just had a hard time, I think, pulling out of it exactly what the grounds for reconsideration were. And I think it's sort of for that reason that I'm not inclined to grant reconsideration on this.
Anyone else? Seeing, let's see, we may want to wait for Member French to, oh, she's here. All right. So Ms. Barella, will you call the roll?
Member Crawford.
To restate the motion, would you restate your motion, Member French, just to be clear?
Okay. I make the motion that we not grant the appeal.
Ms. Morella, please call the roll.
Member Crawford.
Yes.
Member French.
Yes.
Member Dr. Cass.
Yes.
Member Nixon.
Yes.
Thank you. That motion passed on a vote 4-0.
Okay, we are at item 10, review of cases. So we have I believe we've considered these cases by group in the past, and so we are at item 10A, administratively closed cases. There are 3 administratively closed cases: 178-21, 210-21, and 225-21. So do I have a motion to accept the findings of the agency in administratively closing these cases?
I have a motion to accept the findings of those cases.
And I'll second that. So discussion on these cases? Is there any discussion?
Yeah.
Member Crawford.
I wanted to just briefly comment on 225-21. I concur with administratively closing the case, but it just stood out to me that we had 2 different cases that came before us this month that were both related to specifically APD's role in issues that occur where a hotel wants a resident removed. It feels to me like this might be something that's worth the board looking into a little more, just because there might be an opportunity. I don't know if there's a policy improvement here, but maybe at least some kind of education could be done just to cut down on the frequency with which this kind of issue comes up.
Thank you. Is there any other comment or discussion about accepting the agency finding in these 3 administratively closed cases? Seeing no further discussion, Ms. Morella, would you call the roll, please?
Member Crawford.
Yes.
Member French.
Yes.
Member Dr. Cass.
Yes.
Member Nixon.
Yes.
Thank you. That motion passed on a vote 4-0.
Okay, we're at item 10B, which is unfounded cases, 183-21 and 185-21. We have a motion to accept the findings of the agency in these unfounded cases.
So moved.
I'll second. All right, thank you. So any discussion on these?
Once again, I'll just offer a comment on it's 183-21. We received a recommendation for a policy recommendation. That sounds weird. The investigator on that case sent us a proposal for a policy recommendation. I'm actually realizing I haven't read that recommendation yet, but I think it does ensure that we'll take that issue up. There was some confusion in this case about how the next of kin, basically of the deceased person, was notified. It seems like the investigator found that that's just an area where there is some confusion right now. It seems like sometimes the medical investigator does it, sometimes the primary officer does it. So I think that is an issue that we'll be taking up in the policy subcommittee, just to try to clarify how that works and hopefully avoid future incidents like this one.
Member French, you have a comment?
I'm sorry.
If you don't have a comment, Member Nixon, yes, go ahead.
Yeah, at the end of it, and a good point, Member Crawford, for what you were saying there. They did try to reach out. So whichever way that goes, whoever's supposed to do it, I think that consistency would probably be better, as opposed to a very good chance it's, both parties could think, oh, I thought you called her. No, I thought you called her. So in this case, at least it was said that they did try to reach out to next of kin.
Thank you. So I would just like to take the liberty of reading the recommendation that was made by, that Member Crawford referred to by Zell Palale, the investigator. And I think it's a good example of applying, what the findings of the investigation to a policy change. And so he writes, the purpose of this memo is to alert the policy subcommittee of policy recommendations arising out of a complaint concerning a citizen's death notification. Various SOPs were reviewed. 21-51 or 5A1D was eventually used for this tragic case. However, it should be noted that there is no specific SOP covering accidental death notification for families next to kin or hit and run fatality notification for families and next to kin. The current SOP that exists include suicide, natural death, and violent homicide. It is recommended that a fatal crash, fatal accident, or fatal hit and run SOP be created to help provide clarity of personnel roles. A general death notification procedure SOP should be created where the responsibilities are clearly defined. There needs to be an SOP that addresses fatal traffic accidents and responsibilities, as this issue has been reported to frequently arise. So with that, seeing no further discussion, Ms. Barella, would you call the roll?
Member Crawford?
Yes.
Member French? Member French? You're muted, Ms. French.
Yes.
Thank you. Member Dr. Cass?
Yes.
Member Nixon?
Yes.
Thank you. That motion passed on a vote of 4-0.
Well, all right, we're at item C, unfounded and not sustained. There's one case, 193-21. I move that we accept this case, the agency's finding in this case.
So moved.
Thank you. I'll take that as a second. So, all right. So is there any discussion about case 193-21? Member French?
No, I was shaking my head no.
Oh, okay. I was looking away. I was trying to find my, if I had any notes that I wanted to. Okay, so seeing no discussion on this case, Ms. Barella, would you call the roll?
Member Crawford,
Yes.
Member French,
Yes.
Member Dr. Cass.
Yes.
Member Nixon.
Yes.
Thank you. And that motion passed on a vote 4-0.
All right, next on the agenda are the item D, exonerated cases. Those cases include 172-21, 179-21, 181-21, 182-21, 184-21, 200-21, 212-21, and 221-21. So do I have a motion to accept the findings of the agency on these exonerated cases?
I'll make that motion that we accept the findings on the exonerated cases.
I'll second. So is there any discussion?
Yeah, there's some discussion, and I think we could kind of move on. You know, and this is just an observation in looking at all these cases. They have one thing in common, and I don't know if it's burnout or, you know, just an approach that these officers have. I saw in several of these cases where the attitude or behavior of the officer was founded, but did not violate any SOP. And in my opinion, looking at these cases, one of the things that's most disturbing, and I'm hoping someone from APD is considering this, is just the attitude and the behavior of some of the officers on many of these cases. They seem irritable. They seem to escalate the situation unnecessarily. And I think that there's a little bit more tact and diplomacy that can be taken. Again, with the findings of the investigators and on these different cases, it was found that, you know, there were no violations on policies, if you will, but the attitude and behavior is obviously there. And that's why I asked earlier in the meeting about how the officers were doing, because that irritability and that attitude is definitely showing up, at least on OBDR.
Thank you, Member Nixon. Any other discussion on these cases?
I had two items that I wanted to bring up. The first, in 17221, something that just kind of stood out to me about this case is that it's something that the investigator kind of ran into, is that there was a situation where, basically, if I can summarize it correctly, the SOP that the communications operators were using was basically a newer version than the one that's published. So the investigator got kind of confused as to why, you know, their like training was different from the SOP, and that turned out to be why. That just kind of stood out to me, and I don't know if someone, maybe Director McDermott, can speak to that, but is that typical? It seems odd that they would be kind of training people on a policy that isn't the official one, seemingly.
Yes, I can share, Dr. Cass and Member Crawford. So in the review of this case, that was an oddity, and that is not typical. The situation with the communications policy, and I'm kind of paraphrasing, there's been a lot of different communications about this, but the policy has been under revision for quite some time, has been back and forth through different discussions, is my understanding of it. And so the issue was that there was a revision in call priority, and that did seem to be different than what the published policy was. So the board has probably noticed in our investigation, we did recommend that a special order be issued. If that's, you know, what the department is going with, then it does need to be published in some way, whether it be special order, which is how the department basically modifies policy until the policy itself is fully redone or updated, or, you know, whatever word you want to use for it. So That was our understanding. That was the information we received from the communications department, that it was out of necessity that some of this information be updated and revamped because the policy itself was too old, but it just didn't seem to have translated to an actual special order. And I can't answer to why that is, but that is the mechanism that usually happens. And that is what we recommend that occur, that if this is in fact how the employees are being trained and what the standard is that they're supposed to be doing according to their supervisors, then that needs to be in a special order. And that's why you found observed the findings that we had, where we did wind up exonerating the employees in these situations, because based on the training that they've been receiving, it was within policy, but the way the published policy was, it did have a difference. So that was where we were kind of struggling with that initially. And that's hence our recommendation to have that codified in a special order.
Thank you, Director McDermott. The second thing I wanted to bring up, which I think is maybe going to be something for the policy subcommittee to look into in the future, in case 22121, something that came up in that case is that I think that if I can successfully summarize it correctly, someone was pulled over on the freeway for speeding, I think, when the officer got behind them with lights flashing. I think they drove to the next exit and then kind of got off the freeway ways to a parking lot or something. The officer cited them, I think, for, failure to stop when pulled over, basically. And the person complained, I think kind of rightly, that they, thought they were doing what was best for the safety of themselves and the officer. And the officer, when interviewed, said, I didn't write down this quote, but I think they said something like, normally if someone doesn't pull over right away, then they cite them. I think the investigator didn't find, and I didn't find any policy that addressed that. It seemed conspicuous to me that I think I kind of agreed that it seemed like the person behaved reasonably, and the officer did not. It felt to me like the officer did not really justify that decision. They just kind of said it's their normal practice to write a citation for not pulling over immediately. I think probably there needs to be some sort of official answer to that question. I think that's basically my thoughts. I'll probably raise it with the policy subcommittee.
Well, to kind of add to that, Member Crawford, the gentleman in that particular scenario, he had let the officer know that he was a former law enforcement officer himself. So, if a former law enforcement officer is going through that rigor to say, okay, let's go somewhere safer, and had said, looking out for him as an officer, that's kind of pointing back to where I was saying earlier about the irritability of our officers and what's going on. And, maybe this, the high attrition rate / low number of officers on the street are basically, it's kind of wearing on folks, because that's not even normals. I mean, for example, a woman maybe driving, may not feel comfortable in a dark area and decides to pull over to the gas station. If that gas station is a bit of a way away, but in the direction, does that mean that they can technically be cited for not stopping immediately? And would that be upheld? I don't think so. So, that's just some things to consider as well.
Is there any more discussion by the board on these cases? All right, seeing no further discussion, Ms. Barella, would you call the roll to vote accepting the findings of the agency in the exonerated cases that earlier?
Member Crawford?
Yes.
Member French?
Yes.
Member Dr. Cass?
Yes.
Member Nixon?
Yes.
Thank you. That motion passed on a vote of 4-0.
Okay, if you can hang in for a few more, we'll get through these and then we'll take a break. So we're at item E, exonerated and unfounded. There are 4 cases, 167-21, 194-21, 204-21, and 205-21. I move that we accept the findings of the agency in these 4 cases. Do I have a second?
Second.
All right, so is there any discussion by the board on these cases? Member French, are you leaning forward to make a comment?
To vote.
Oh, you're ready to vote, okay. All right, so is there, one more time, is there anyone have any comment or discussion about the exonerated unfounded cases? Seeing no discussion, Ms. Barella, would you call the roll, please?
Member Crawford?
Yes.
Thank you. Member French?
Yes.
Member Dr. Cass?
Yes.
Member Nixon?
Yes.
Thank you. That motion passed on a vote 4-0.
All right, we are at item F. Exonerated, not sustained, and administratively closed. There's one case, 189-21. I move that we accept the findings of the agency in this case. Is there a second?
Second.
All right, thank you. So discussion? Member Nixon, you're still unmuted, so do you have any? All right, thank you. No, hearing no, seeing no discussion, hearing no discussion. There's a motion to accept the findings of the agency for this case 189-21. So Ms. Barella, would you call the roll?
Yes. Member Crawford?
Yes.
Member French?
Yes.
Member Dr. Cass?
Yes.
Member Nixon?
Yes.
Thank you. That motion passed on a vote 4-0.
Okay, we're at item G, sustained. This is case 191-21. I move that we accept the findings of the agency in this case. Is there a second?
Second.
All right, discussion? All right, so I'm looking for another opportunity for discussion, or seeing no discussion on this case.
I'm sorry, Dr. Cass, I had something to say. We're on the
Right.
191-21, is that where we're? Or 189-21?
191-21, I believe.
Okay, I had since we're open for discussion, I just want to say that after looking at most of these cases and reviewing most of these cases, the one common denominator is the length of time that it's taken to investigate these. Like this particular case was sustained. It was filed in September and the individual wasn't interviewed until January. And I found that to be common among most all these reports. And I just hope that now that they've hired additional investigators that, you know, we can do them in a more timely basis, because if I filed a complaint 4 or 5 months ago, it takes you 4 or 5 months to get back to me. I pretty much have forgotten it, probably don't remember all the details. And I just think that's a pretty long time to wait to have your complaint looked into, especially when it's sustained. So I just wanted to make that comment.
Thank you. If Director McDermott would like to respond, I would invite her. That she's certainly can respond. So.
No, and the point's taken. I mean, I understand the process in general is a long process. These cases were completed within the 120 days. The goal would be to obviously be shorter than the 120 days, but given the length, given the staffing and given the numbers of complaints that each investigator has, there is currently still this kind of running up on the deadline. But hopefully that will improve once we have all the investigators fully trained and ready to go. Then the goal will be to be less. But for now,
well,
unfortunately.
Diane, I was looking at the date that it was received a case number, and the date of the investigation said they called the complainant. That's what I was looking at.
Right.
Okay. the time that it takes them to even start looking at the case.
Right.
So, you know, I'm not saying anything in a negative way. I'm just saying,
Okay.
hopefully that this will improve in the near future. That's all.
Agreed. I hope so. Yeah, that is the goal. That is the goal, not only to get the cases investigated faster, but to be able to reach out to the complainant. Usually the investigator reaches out to the complainant when they're ready to like basically work the case pretty diligently. So, you know, I agree with you. I mean, yes, the goal is to try and shorten that time span. So that's what we're going to work towards.
Oh, is there any other comment or discussion from the board around about the case 191-21? Seeing no further discussion, Ms. Barella, would you call the roll?
Member Crawford,
Yes.
Member Friend,
Yes.
Member Dr. Cass,
Yes.
Member Nixon.
Yes.
Thank you. That motion passed on a vote 4-0.
All right, we're at item H, sustained and exonerated, case 202-21. I move that we accept the findings of the agency in this case.
Okay, I second that, but I have a question on that.
All right, there's a motion made and seconded, so this board discussion. Member Nixon, you have a question?
Yeah, how is it that an officer can state something that's false to somebody that they're detaining and it's against a violation? I just want them to validate that. I mean, it doesn't violate any SOP or anything. And I guess I'm asking you that, Director McDermott, because you guys did the investigation. So literally they can make a false statement. It didn't go against any SOP or policy.
Chair Dr. Cass, Member Nixon. So unfortunately, I did not refresh my memory as I didn't receive any question prior to, so I don't honestly remember which case this is or what the issue is. So, I mean, I'd be happy to try and look into that more, but I don't have an answer for you right now. I mean, I can only give you the information that was provided in the case that presumably would have the answers to that question, but I don't think I could quickly.
If I can interrupt, I believe, I think this complainant was going to ask for a Zoom appearance. Is that correct?
That is correct. She did inquire and make a request to join the meeting, and it was sent to her. I'm not sure if she joined or tried to.
No, there was no one in the waiting room for this complaint or the next complaint, both of which had indicated they were planning on attending, but neither actually showed.
I can quickly read the complaint if that helps Member Nixon in terms of putting some perspective in this case. The complainant reported that while traveling west on Paseo at 64 miles per hour, she passed an officer. The complainant's name is Capnison reported that the officer proceeded to speed up and on multiple occasions kept shining his spotlight on her. Ms. Capnison reported that she asked the officer why he pulled her over, and he stated because she disrespected him by passing him and he could arrest her. She reported she told the officer multiple times that she wanted to go to court. She reported the officer gave her a citation, which was marked at the penalty assessment line. She reported that on the citation, the officer did not put her correct license plate number. So there's some background in this case. And I believe there were two findings. One was sustained and one was exonerated. The comments made by the investigation was regarding 1-1-5C-3. Officer A expressed officious behavior and personal feelings during the incident by threatening to take Ms. Capnison to jail for something that Officer A confirmed that he could not arrest for. Officer A also implied that Ms. Capnison's attitude was a large factor in giving Ms. Capnison the citation.
So to put it simply, all I'm asking is, and this is basically to ask Dr. McDermott, you don't have to answer this now, perhaps maybe a quick email with, if you could talk to that investigator or just kind of clarify that. There was literally no SOP or policy that was violated by him making a false statement as to telling someone that's detained that you can arrest them. That's all. It's a curiosity question, more or less, but I guess now it's more than curiosity. I'm a bit concerned about that, but I just want to know if it violates anything.
Okay, I think I understand your question. So you're basically, because the officer had made the allegation that they could be taken to jail when in fact they could not be taken to jail for that specific issue, that's what you're saying
Yeah.
would be a violation, a
Yeah.
different violation.
Well, yeah, I don't know if it is or not. I'm just asking, you know, with all the SOPs and everything you have at APD, this doesn't violate anything?
Well, I mean, the officer was sustained for making that allegation. So basically, as we looked at it, that would be considered officious conduct, basically that you are telling them that this can happen to them when in fact it could not. So that would fall under basically kind of that definition of officiousness. I'm going to take you to jail would be an officious statement when in fact they could not take them to jail. So that was a sustained issue. I guess you're looking for kind of a different SOP, but the way it's defined in our estimation and the way it is defined in the policies, not that I know every policy from heart, but I think that would fall under that, you know, basically an officious statement. And that was, we agreed, that was an officious statement and therefore it was sustained.
Okay.
Thank you. Is there any other discussion concerning this case? Seeing no further discussion, Ms. Barella, would you call the roll, please?
Yeah. Member Crawford?
Yeah.
Member French?
Yes.
Thank you. Member Dr. Cass?
Yes.
Member Nixon?
Yes.
Again, that motion passed on a vote 4-0.
Okay, that brings us to item J, not sustained. There's one case in this.
Sorry, Chair Cass, it's item I, not sustained.
Oh, I'm sorry. Okay. Item I, not sustained, 197-21. I move that we accept the findings of the agency in this case. Is there a second?
I'll second that.
Thank you. All right, so discussion. Going once. Right, so seeing no discussion from the board, Ms. Barella, would you call the roll?
Yes, and just for the record, this complainant did reach out and did receive a Zoom invite to attend the meeting. Member Crawford?
Yes.
Member French?
Yes.
Member,
yes.
oh, thank you. Member Dr. Cass?
Yes.
Member Nixon?
Yes.
Thank you. That motion passed on a vote of 4-0.
So we are at, yes.
I just wanted to make one mention since Ms. Barella had mentioned this. We did send this invitation in Spanish since that was of a concern. And we did have a translator available in case she did arrive. So I just wanted to kind of make a note of that we did, you know, make sure that those accommodations were there. So.
Thank you. Thank you.
And,
so
and
we, yes.
Can I make a recommendation? The last, the serious use of force cases that are there, unless somebody objects to that, if before we go on break, can we just vote on those to accept those findings? I didn't have anything with it, but I just thought I'd throw it out there just in case anyone had anything. Or we can.
I would. I think. I'm sorry.
What is the motion again? What did you say?
That the serious use of force cases are accepted, the findings of those.
I think we, you know, I would prefer to keep this, to not deal with this issue until after the break.
Okay.
So what I would recommend now is that we take a 15-minute break and then return to begin item 11, the serious use of force cases.
Okay.
Yeah, I have a couple of things that I want to bring up about that too, so I'll do it after the break. Thank you.
All right, so if we return at 7:35. All right, welcome back. This is we're past break at the meeting of the Board of the Civilian Police Oversight Agency. We are at item 11 on the agenda, serious use of force cases and officer involved shooting. And I'd like to say a few words of introduction and a couple of words of apology. I tried to improve this process, and I think I'm hoping that we can streamline it. But just to give you some background on where the status of this is, we have something like 122 cases that we've gotten some kind of information on regarding these level 3 uses of force from APD. They date back to 2016. There's only a couple in 2016, and one of which we have yet to hear. But of the 122 cases, we've gotten some amount of information. We've gotten the FRB chief report on 98 of these, and we've gotten PowerPoint files on 95 of those, and we have full investigative files on 14 of those. And of course, of those cases, we've reviewed about 68 cases in the last year and a half. And one of the things that has been called to my attention by a couple of different sources is that we should change our focus to focus more on the outcome, our findings of the case, and a way to formally report those to the public, and as well as APD, the monitor, the DOJ, and the city. So it's something that was not very well defined when we sort of inherited this process to be the final review for that comes after the Force Review Board. And so we've kind of, been slow to really, put together a process for how we're going to formally give the findings or produce the findings that we come up with in each of these cases. And we have, as I mentioned, we have 68 cases that we reviewed. I think we have only made a couple of formal recommendations on a couple of these. And I think we need to go back and figure out a way to perhaps write a letter which groups the cases that we've heard and produces produces the findings associated with what the case at the time. Right now, all we have is a record through the minutes that we've accepted the findings or rejected the findings of the Force Review Board. And so what I'm suggesting is that we think about a way to create a plan for going back and supplementing that information and creating a report that that deals with this backlog, or it's not a backlog, it's a set of finished cases that I think we owe a report to the public for. So I'm one of the things that came to mind is that we each take a hand of 5 cases and go back and research, if it means researching the minutes or researching the video, to determine what our findings were, so that we can produce a more than just a simple accept or reject sort of vote that we are doing that. I don't think we can come up with a solution tonight, but I just want to plant the bug that I think we need to move in that direction to where we actually produce a written assessment or document or of what it is our decision has been on these cases. I think that also leads into a more thorough review of results as opposed to the time that I think I spent in the last meeting, where it took an inordinate amount of time to go through the case, essentially view graph by view graph in terms of the PowerPoint presentation that was made. So what I did for this meeting, and you excuse me, you all received a set of templates for the cases. And I apologize for the fact that I think I duplicated one of the cases in 2 of the templates. So the basic information wasn't quite accurate. But in any case, what I thought we could do based upon following this template is to use the information from, that describes the case and which has been put out in the PowerPoint slide that deals with the sort of the setting for the case, and then go through the results, the things that we're here for, which is the dealing with the type, the force that was used, dealing with whether there was, whether there was de-escalation techniques that were used, which is part of the part of the process for dealing with use of force cases. And then the constitutional elements of the case, the Graham factors, the reasonable, necessary and proportional use of force, and then the application of these facts to the policy. So with that, I would, if there's any comments by the board as to how we should proceed or modify this process, I'd certainly like to hear them, because I think we need to improve the process. So Member French, you have your hand up.
I do. And Dr. Cass, I appreciate all the hard work you put in that template. It took me by surprise because we've never done that before. So I started going back and remembering the meetings I had been in, and I started doing a little, I never remember that. And you're right, the last few meetings, it took several hours to go over all those cases. But as you know, we just reviewed the ordinance. Well, and also I was looking at the CASA, but what is missing is, like, when Ed was here, Ed would go over all these cases and give us his recommendations. And I believe if I looked at 1 or 2, he would have a letter ready for the chief. But also in our ordinance, it says the director shall prepare and submit findings and recommendations to the board relating to officer-involved shootings and serious use of force, and shall report on general trends. So before I can even look at these cases, because the director, I think, attends those FRB meetings, and it shouldn't be recommendations and review from a board member. It shouldn't be a board member going over all those cases, because we as a board should be reviewing them before we get to the meeting. But we absolutely need that review and recommendation by our executive director on what she finds, whether she concurs, whether she doesn't, why she doesn't. And I believe, and I know that's what Ed used to do. And then also it's in the CASA, that's what we're supposed to have, that the city shall implement a citizen police oversight agency that provides meaningful, independent review of all citizen complaints, serious use of force, and officer-involved shootings by APD. So before we can make any decisions, I saw your form. I won't be using that form because I don't think it falls within our duty to document. What we're supposed to do is read and listen to our reviews and recommendations from our executive director, and then decide whether we accept or don't accept that. So I think this process lately has been taken completely out of what the ordinance says and what the CASA says, but I could be wrong. So I'm going to ask for a legal opinion from Ms. Gooch, because on 9-4-16, and I think it's B2, that's what it says, that the director shall prepare and submit findings and recommendations on these cases. And that's what Ed used to do. So personally, I don't think we should be voting on this until we get that information. And so I'm going to ask,
before you, yeah, thank you. I don't mean to cut you off, but I just wanted to respond in that we're trying to fill a hole here where we have cases that were before the FRB, and the former director who heard those cases no longer is here. So we don't have the benefit of the findings from his tenure. And so we're trying to, put together a process where the board does have a role in reviewing the cases, and implied, I think, in that review is that we produce a set of findings. So I agree that we're lacking in terms of having the director's findings to help us in that regard, but it's the best we can do at this time because those force review meetings have been held in probably 80 or 90% of the cases. And so they weren't available. Director McDermott was not able to attend those. So that being said, I think it's still worth the, answering your question.
Well, Dr. Cass, I disagree totally with you because I'm not saying that member McDermott, interim director should have it today, but the agency has access to these reports just like we did. And they're the experts. They're the investigators. We can't just sidestep the ordinance and the CASA because he's no longer here. We can't. I disagree, and I won't be. I don't think it's right, and I won't be voting on these until we have that expert opinion. We're not experts on these, and you're right. We read them, review them. We have our opinion, but just like on those non-concurrents. Diane's review and recommendations were invaluable, and that's what we need, and that's what's required by the CASA and by the ordinance. And I'm not trying to be throw a monkey wrench into what you're doing. I applaud you, and we need to get some things done, but we also have to follow the ordinance and the CASA, and we can't sidestep it because there's a backlog. So that's my opinion. So I don't think that it's fair to the cases, to the complainants, or to the officers if we don't have that expert opinion and recommendation, review and recommendations as stated. So that's my opinion on this whole issue.
All right, thank you. So if Ms. Gooch, if you would, Member French has posed a question, and you weigh in on this, please.
Chair Cass, Member French, I need time to look into the issue. I can't render a legal opinion on something that is brought right now on what the ordinance says and how to interpret, given the fact that the director that was on the FRB for these cases is no longer here. But if that's something that the board would like me to do, I'm happy to do it. I just can't give an easy answer tonight.
Well, then my question to this is, I understand that the director is not there, but we have an interim director, and I value her opinions, reviews, and recommendations too. So, she has access to all the files just like we do. So I think that's necessary in order for us to make a decision based on investigator, the executive director. That's all I'm saying. So, and I'm, what brought my attention to this, Dr. Cass, is when you sent that form. And so I started looking, saying, we've never done this before. What is this about? And so I went back and listened to some meetings, and then I started reading. I looked up the ordinances because I wanted to know why all of a sudden are we changing our process and procedure on these reviews. And the last couple of months, as you said, it was painstaking to sit here for 2.5 hours and go through PowerPoint by PowerPoint by PowerPoint, slide by slide by slide. So I just think that there's a better way, a better process. And I also, as I said, I think we'd be violating the ordinance and violating the CASA if we make decisions on these serious use of force and officer involved shootings without that expert review and recommendation.
And even when Director Harness was here, we didn't go slide by slide because we were responsible for, reading up and looking at reviewing the use of force cases. he would basically give his synopsis, and then we go forward. If we had any questions or any discussion, we do that, but then we move forward with it, as opposed to reading through every single slide and everything's going.
But he did give his, I went back and listened to the things, he did give his review.
He did give a review, that's correct.
So, and that was the point of removing the slide-by-slide process in terms of a presentation and relying on the board to do their review of the PowerPoint presentation themselves, which includes the information, that IAFD has come up with regarding whether this was a legitimate, whether the force was reasonable, proportional, necessary, whether there was, it fit the Graham factors, the other constitutional factors. That's the basis that we're supposed to be deciding these cases on. And so this isn't a new process. The question is, how do we, in my mind, the question is, how do we produce the results? And I think there is a fair question as to what the role of the director is, but I think that we need that information, and it is called for in the ordinance, but we do have an obligation also to review these cases.
And we know our obligation, Dr. Cass. I'm not sidestepping that at all. But our obligation is also to get a review and a recommendation.
It's a sidestep of the obligation if we say we're not going to do this unless we have a director's opinion first. So and knowing that we don't have that available because we don't have the director who sat in on these force review board meetings, from which most of these cases come.
What,
so,
Dr. Cass?
So these have happened.
No, that's not.
The cases have happened, and the director's opinion was based upon attending the force review board meetings.
Dr. Cass, you can say his opinion was based on, your opinion on what he did or what he didn't do. But I'm not saying, I'm not sidestepping my duty, but I can't do my duty until we get the information required by the CASA and by the ordinance. That's all I'm saying. So I understand that there's a backlog, and I understand that you want to catch it up, and I certainly do too. But I'm not one that says because we have a backlog and because we need to do this, I'm just going to disregard the ordinance and the CASA right now and just move forward without that expert recommendation and review. That's all I'm saying. And like I said, as we saw today, Ms. McDermott's review and opinions was very, very helpful.
Agreed.
So what's the, it seems to me that we're at a situation where we need to decide whether we want to go forward. We can, the option is to, review these cases as presented, or to table this until we receive a legal opinion as to whether we can move forward with regard to, and satisfy the CASA. So if that's a legitimate question, then I need to hear the sense of the board as to what they want to do.
The cases were reviewed by the board. I'm assuming everyone here that's on the board has reviewed the cases. Is that a safe statement or true statement?
I'm sorry, I didn't hear what you said.
Has everyone on the board reviewed the cases?
All right, let's assume that's true, and then continue, please.
So we're talking about this process, and the way I see it is, if we've reviewed it already, then basically we just need the summary of the findings that's come out. If we have any questions about that, just like we did before when Director Harness was here, we could ask the questions. But since we're all have the responsibility of reviewing the cases, and we've done that already, going through these cases should not be a situation where we have to go through every single thing that we've already read. It should be a synopsis that comes out of it.
And that's exactly what I suggested.
I think that Director McDermott is more capable of, looking at any cases that are supposed to come up. For example, these 6 cases that are supposed to come up, or excuse me, 5 cases that are supposed to come up. taking a look at those, what that review was, or should I say what that summary was. And if she does have an opinion on it one way or the other, which she tends to weigh in whenever, there are things to be said from the director's point to weigh in on those. And I'd like to hear Director McDermott kind of comment on this one, what she's saying.
Director McDermott?
Yes, thank you, Chair Cass, Member Nixon and Member French. So yes, we are in a difficult position of these reviews were completed during the Force Review Board, and that is what Director Harness would base his letters on. I don't have the benefit of those meetings, so my review would consist essentially of looking at the minutes of the case. I'd have to explore whether or not I would have the ability to go back and pull the materials and try and do some sort of an assessment for these cases. But I guess I would just have to explore that. So, I mean, you've posed the question to Council Gooch, and I guess I'm not prepared to necessarily say, yes, I could, no, I can't. It's just there is a gap basically between the situation. So I guess that's what I say, is that it would be difficult, let's put it that way, for me to go back in time and try and review the cases and come to some sort of a conclusion when I didn't have the benefit of the materials, since I do have current FRB cases that I am having to review on a weekly basis. So it's difficult for me to go back in time and add that to the workload. I'm not saying it's not impossible. I would have to figure that out and figure out if that's an option, if that's possible. More likely the review would be based on the minutes. So the board actually has more of a benefit than I do when it comes currently to these cases, and that you have reviewed the materials and have that. The minutes would be mostly what I would have to rely on in terms of that without going back. So again, trying to balance workloads, I'm not sure, but it's something that I guess, we could figure out if there's some sort of leeway with the ordinance, like you said, with Councilor Gooch talking about that. So
Diane, I'm not trying to put you on the spot. Don't get me wrong. It's just when Dr. Cass sent that document, I started doing a little more research. But I just have one question for you. Do you have all the same material we have on these cases?
No, I don't actually. I mean, I could get it, but I don't review it. I don't have it currently.
But you have access to it just like we do. You can go on the share drive and all those different places. Just because you upload the information, you have access to the same.
I don't actually upload that information. That's coming directly from APD. The only thing that you're receiving from me is when APD advises that there is a case that has been redacted and that you've requested as a board to see the videos and those are redacted, then I have the mechanism. I'm told by APD, hey, this case is done. The videos are redacted. Please share the videos with the board. So that's the only thing you're receiving from me. Everything else is being received directly from APD in terms of those other links, the PowerPoints and all that stuff. I've provided those links to you just so that you have it, but that is actually built and constructed and maintained by the APD Force Review Board administrative person. I don't know what her title is exactly.
Okay. I understand what you're saying, but what I'm saying, if you provided us with the link, you also have access to the link, correct?
Right, I can look at those materials. Yeah.
Okay.
This is the question I have. The sessions that Director Harness sat in on, was he able to render his findings on the backlog? Or is there anything that's outstanding at this point that he has not rendered an opinion on?
He only is an observer at the Force Review Board. The only time he renders an opinion is when the case comes before our board. And he prepared in advance of our review of the case, he would prepare his findings based upon his experience with the Forest Review Board that heard that case.
So there are cases out there that he has not rendered an opinion on yet for us on our side.
None of the cases that we, the cases that he's rendered an opinion on are the ones where he was here as a director and we heard those cases. So I can't tell you what number that is, but you can look at the, at the minutes and see which cases were reviewed when he was the director. And at that time, he had a summary, or he had prepared his remarks on each of those cases. So that's where, and the cases which he sat in on the Forest Review Board, which we have not yet heard, there's no record of any of his findings on those cases that we've found, or that Director McDermott has found.
Okay, so based on what Member French is saying, can we have council weigh in on that?
I think she just said that she needs time to research it.
Right. And just so that you're aware, like, so the FRB process, basically the FRB chair polls the members and asks, have you reviewed the file? So kind of what you just suggested, Member Nixon, that everyone says, yes, I've reviewed the file. Yes, I've reviewed the file. And then you would be in the position to discuss it. And I understand what Member French is saying is that there is this portion of the ordinance that is saying that the director has these findings. So I guess, that's just something that would have to be explored. But as to having current letters, at least as Chair Cass had mentioned, we haven't necessarily located any that were available that I can share with the board. Maybe we need to try and find further, but don't have that, at least at the disposal that I'm aware of right now. In terms of going back in time and trying to review the materials for all those various FRBs. Again, I just would have to figure out if that's something that is possible with everything else. So it's just a discussion that I guess we could continue to have, but you do have these cases tonight that in theory have been reviewed, and as you did the previous couple of months, so.
Okay, so in the event that we get another director, then isn't that director going to be in the same position? So what are they supposed to do to address these?
For a time, that is going to be the case. So don't have an answer for you exactly as to how to remedy it until we decide if there's some sort of a workaround, I guess. Or the board can basically decide, yes, we're gonna do this, kind of as Chair Cass has recommended, at least for tonight.
So just one other point, and this is a process that the board voted on and approved. So it's not a new process. We have conducted it several times in current
Could you tell
situation.
me when did the board vote and approve on this? Because this is the first time I saw your document, Dr. Cass. Maybe that was before the time I got on the board.
I can't give you the exact date, but we've been doing this for a year and a half.
I've never filled out that form you have, never.
No, and that I've produced that form this, within the last week or so. So, but it's a reflection of what is of the process. It's simply a reflection of the information, the standards by which we review the case. And I also produced a review process that summarizes the evidence and the complete process that is in SOP 258, which is the Forest Review Board. Those were circulated to the board as well. So the process has been out there. It's been exercised. It isn't a new process. We're having to do a workaround because we have a change in directors. But it's, it is what it is.
I agree with you. I think the process has been here for a year and a half, but it's not the process that we witnessed last meeting.
And we're not talking about repeating that.
The last couple of meetings.
Indeed.
We're not talking about repeating that. To streamline it, I recognize that that was a problem. It took a period of time. But if you also happen to believe this is one of the most important pieces of work that the board does. This is what we are about. This is about constitutional policing. Constitutional policing deals with use of force, essentially. It deals with arrests. And
I agree with you, Dr. Cass.
and
That's
so,
the reason I think we should skip steps.
I don't believe it's a fair objection to say that we spent too much time on this, because we just now spent what, about approximately an hour and a half, I would say, on the on citizen complaint cases. You know, it's a similar sort of situation. So I mean, you can object to the process, but it's not a new process, and it's something that we've exercised in the past.
There's no objection to the process. I think that that's erroneous. Nobody's objecting to the process. We realize and we all agree that we need to do this. But in the interim of what's happening now, those changes, and we agree that there's some changes that need to be made, are what we're actually talking about. We're not trying to replace or change the process of us reviewing these cases. But there's a much more of a streamlined way of doing that. And I don't think we have to read through every single slide in order to do it.
And that's exactly what I've addressed. That's exactly what I've addressed, and I've tried, and I've repeated now, that we're not going to go through every slide. I gave you a summary, and the rest of this is up to you to fill in the blanks. And if you choose not to, fill in a blank, then that's your choice. That's your decision. If you choose not to judge the case based upon the factors by which it's supposed to be judged, according to determining whether it's a constitution meets a condition of constitutional policing, then I contend that that's a decision that you're making that's contrary to the intent of this case review.
And I disagree with that, because I don't feel like I have to answer every single thing according to what your template is set up, especially when I've already reviewed the cases. Now, there may be some things that I disagree with, like we've done in the past, where I can bring that up or address that as need to. But no, I have no desire whatsoever to go through your template and say, well, I've got to fill out every single thing. The things that come down to me, because I'm reviewing the case and I'm reviewing the slides and I'm reviewing the videos and everything like that with the use of force, then what we've done before said, hey, this has been reviewed. These are my findings. These are my concerns. And then we've come up with those. I like the idea of the template because, the stuff is right there to look at. It's a good reminder. But as far as whether or not I answer every single one, it's not a determination as to whether or not I thoroughly looked over that use of force case.
And I appreciate that. The template is not intended for you to have to fill in every blank. It's intended as a guide, just as you described it. However, the standards by which use of force cases are reviewed have been laid out by essentially under the guidance of the monitor team, and as to how these are going to be presented and reviewed by the Internal Affairs Force Division. We've also received the training as to how those cases were to be what the Force Review Division did to arrive at their findings, and we were then trained as to to interpret or be able to follow through on what they had done. There's an extensive, I believe that's part of the training materials that you received. So we have a process that's been laid out for us.
Dr. Cass, I would like to say something. I think you're taking what I'm saying out of context. I'm not saying that we shouldn't review. I'm not saying that we don't have the knowledge to review. What I'm saying is the executive directors, and these are supposed to be the expert investigators, the executive director has some pretty high MQs because we value their opinion. And it's part of this process. And you can't skip it. You can't skip it because we're behind. And I agree. And I've reviewed every one of these cases. I've looked at the video, I've done them all. But yet I'm here, but I still need that expert review and recommendation as a cause. I'm not trying to get around our duty. Absolutely. It's the same process. We review all the cases, we read them. The part that we're skipping is the review and recommendations from the ED at this time. That's all I'm saying. And we did it the last two, and then I'm not happy. As you know, people watch these meetings all the time, and you know, they read the CASA, they read the ordinance, and that's all I'm saying. I'm not trying to get out of work. I'm not trying to stop to do it, but I am a person that reads the rules and goes by black and white. I don't find ways to circumvent. I don't find ways to skip steps. And so you know, I've read all of them and reviewed all of them, but I just want to bring it to the attention of what the ordinance and what the CASA says. And so that's all I'm saying. I know my duty. You don't have to tell me what my duty is. You don't have to tell me what my procedure is. You don't have to tell me how to do it. I appreciate it, but I've done that. I've done all that, and I know what it is. I just think it's so important that we follow the ordinance and we follow the CASA when it comes to the serious use of force and the officer involved shooting. That's all. I'm not trying to do anything else but that.
Sure, Dr. Cass, could I be recognized?
Yes. Member Crawford.
It seems to me that we are having two different debates right now, which is complicating this. I think the first relates to the templates and the second relates to the point in the review process that we're at right now. As to the templates, it feels to me like there have been complaints for the last 2 to 3 meetings that this process was taking too much time in the meeting. I tend to agree that reading the Force Review Board presentations in the meeting is not productive, but it does seem like Chair Dr. Cass introduced the template as an effort towards, you know, providing a faster way to get through that process. I did not understand Chair Dr. Cass's email to make this a mandatory process or board policy, and that would require a vote of the board anyway. I was of the understanding this was just an effort at providing a work aid to get through those reviews a little more quickly. I don't know that I completely love the template, but I appreciate that effort by Chair Dr. Cass, and I don't know that we need to have a long discussion about the templates themselves unless there is a proposal to make it board policy, which would be sort of a different matter. And I guess we could cross that bridge when we came to it, but I just don't think we really need to have that discussion at the moment. When it comes to the point that we're at in the process, you know, I understand that the ordinance obligates the executive director to make a recommendation. It seems to me that that has not happened because of turnover in that position, which is unfortunate, but it's the kind of thing that happens and will, you know, foreseeably happen again. I don't think we can really go back and fix that at this point. It's maybe a separate question of whether or not we want to task the current executive director with sort of going back and retrospectively trying to review the Force Review Board, you know, work. I question whether or not that would be a productive use of the executive director's time, given that I don't think that the executive director has access to any materials that we don't. You know, I'd be willing to wait for council's opinion on whether or not there might be any like ordinance obligation to do so. It's just given the knowledge that, you know, or especially given the knowledge that there are already kind of workload and staffing limitations that exist, I'm wary of giving the executive director a new task of kind of repeating work that was unfortunately missed, but that was kind of missed by someone else in another time. And we've kind of lost the opportunity to really have the executive director participate in the Force Review Board and then render an opinion on those cases at this point. Thank you.
I did ask for a legal opinion.
Yes, Director McDermott.
And just to let you know, I mean, whatever comments that the former director was able to make during review board, those are captured on the minutes. So there is, when you've done these last couple of times of you've basically agreed or disagreed, I think agreed pretty much in all the cases with the minutes of the FRB. The director's opinion, I believe, is captured within those minutes. So in essence, you do have that as best. It may not be in the form of the letter, but it is his opinion, I guess you'd say, is reflected in those minutes as far as I know. I would have to go back and look at those minutes, but I believe all those minutes, if he was in attendance, you know, his opinion, his comments, his whatever are reflected. So in my mind, and again, we're talking about legal opinion, but in my mind, you do have what you're asking for, just in a slightly different form, if that makes sense.
Are you saying his opinion, his review and recommendations and opinions are in these current ones we have? Is that what you're saying, Diane, the ones we're reviewing tonight?
I can't specifically say about the ones tonight because I did not look at the FRB minutes for these specific cases, but I can speak in general that if the director was present, the way the FRB works is that it does ask the director is not a voting member, so there is not a specific you know, vote that you see captured on the minutes, but the director is given the opportunity to make some kind of a statement, comment, ask questions, things like that. And those are reflected and captured in the FRB minutes if he was in attendance. So in that sense, like I say, you do have the director's information available to you. It's just not in the form of a letter. It is in the form of the FRB minutes. So that's, I guess, just to add to the discussion or confuse it. I'm not sure which, but
I think that primarily the director, what's in the FRB minutes is a checkbox that says the director's comments were heard. The question is, did the director have an opportunity to present their comments? And I don't believe the comments are recorded.
the later ones, I guess, have been, and that, and again, that's
Okay,
going back in
right.
time, and that's the problem with going back in time, is that processes have changed. All I can speak for is the current, and the current is more reflective of actual commentary and opinions and things like that. So when you're talking about these older cases, perhaps that is not accurate. I can only tell you what the current process is. I don't know what it was back in 20 whenever. So yeah, I guess maybe I misspoke on that. Maybe it's there, maybe it's not for these older cases. I'm not really sure.
And I just went back on, since I've been on the board, Diane, and how we did them. And that's why, you know, I looked at that because I remember Ed always did that for us. So and all I'm doing is I just want to make sure, because these are serious use of force and officer, that we're proceeding and following our procedure and proceeding as we should. That's all I want to make sure.
And if you're, I mean, the ordinance deals with what the agency is supposed to do, but it doesn't. The agency reviews it or not, and so we're not skipping a step on the part of the board. There may be a step that's skipped on the part of the agency, but that isn't something that we have control over, given that this was we have a director who's, different now. So, I mean, there's nothing that says
I want a legal opinion. I understand what you're saying, but I want a legal
opinion.
opinion.
I got the floor, Member French. So, I mean, we're not, we're in what the director does not impact our ability to render a decision. It may impact your, the ability to be confident in your decision because you haven't heard the director's opinion or an expert opinion, but I don't believe it has an impact on the ability for us to make a decision and review a case. The question is how to proceed from here. And, it seems like the sentiment of the board is that don't wish to review the cases until they've heard a legal opinion regarding the regarding whether the director's opinion is necessary for us to continue. So, I mean, I don't believe it's prudent to proceed with a divided board in reviewing a case, these cases which are important. So as chair, I don't know what action I can take other than to say I would table these cases until the next meeting if we can't agree to a process for review.
Dr. Castle, I have a question for you. If
Yes,
Diane,
go ahead.
do I have the floor now?
Yes.
Thank you. What I'd like to ask you is this. If Ms. McDermott wasn't at those FRBs, and I'm not sure, you can go and see who are, who isn't. If these cases are old, I would respect, and maybe it's not a non-biased or a neutral opinion, but I would also respect somebody from the FRB to come to our meetings if possible. If we have any questions or anything else like that, they would be able to do it until she can catch up on the cases. I don't know if that's allowable, but I just think that we need that inside information and that, don't come up with a problem unless you have a solution. So, that's what I always say. So I'm just wondering, would that be possible too?
In my view, that violates the spirit of this review.
Okay.
This is
Okay, then drop it. We don't have to discuss it anymore. I understand what you're saying. Okay.
So where are we on this? Member Gooch or Council Gooch?
Thank you, Chair Dr. Cass. I believe Member Crawford has his hand raised if he would like to go first.
I was going to make a motion, and let's have Council Gooch go first. I'm just wondering if it's going to influence what I was going to say.
Thank you, Chair Cass, Member Crawford. With regard to the FRB, I agree with Dr. Cass that you really do want to keep the separation of the agency and the board so that it can have its independent decision-making. But I appreciate the problem-solving nature of the offer or the idea. As far as the legal opinion that you're asking for, I just want to make clear that I understand. Is it that the board is permitted to proceed with review of these cases without a director's findings and recommendations? Is that the question that is being posed to me, or is it a different question?
That's the exact question that I was proposing. If you look in the CASA, I think it's paragraph 247, but on our policy and procedures on 9-4-16, and I think it's B2, where it says the director shall prepare and submit findings and recommendations to the board. And that sort of thing. If we can proceed and disregard that for now, and you say it's okay from a legal opinion, then I'm good with it. But I just want that legal opinion if we can, like you said, our meetings are watched and people read the CASA, they read the ordinance, and I need that from you so that we won't get somebody complaining or saying that we're not following the ordinance like we always get.
Okay, so I will look into that on behalf of the board, but just from reading the ordinance, it talks about director duties, but it doesn't tie the board in that particular provision. So it could be that we have an out of compliance director position due to the turnover, but I need to look to see if that would impact the board. I don't believe it should or could, but I will look into that. Thank you for clarifying the question.
Member Crawford.
Yeah, I'd like to move that we table these serious use of force incidents until next month and ask council to provide an opinion on whether or not the board is able to proceed with reviewing them.
Do we have a second?
I do have a second, and then discussion. I will second that.
All right. Yeah. Is there any discussion?
Yes.
Member Fritsch.
Thank you. I think if we look on what we have coming up on the directors, looking for a director, for that audition, interviews, etc. I think we do have a special meeting coming up, and I would like to get that legal opinion as soon as possible. And if we can, if it's put out on the open meetings, if it's posted, that we review these cases at that meeting, if it's agreed upon, instead of waiting until our March meeting, and still schedule these cases that you have for March for that March meeting. So that would be my suggestion. And so that we don't get further behind in these reviews.
All right, we have I think we have one motion on the floor, which is to table the review of these cases until the March meeting. So, and we have a second. So is there any more discussion?
I think I said to table until next month. I'm willing to, take it as a friendly amendment that I'd be happy to reconsider this at a special meeting if there is one that happens before the next regular meeting, and if we're able to get it on the notice agenda.
Yes, Director McDermott.
Yeah, I mean, just with the quick caveat in terms of availability, to be able to host a special meeting, we would have to check the availability for GovTV and things like that. So I just, with that caveat, that we have to find an appropriate date if that's what the board wishes to do. And it may not always be possible, but we'll try.
To be clear, I guess perhaps Member French might disagree with me, but I guess I wouldn't propose that we hold a special meeting for this purpose. More that if we plan one to deal, for example, with hiring a new director, then we can pick this up at that time as well.
Okay, and we can discuss that in the timeline for the executive director. But I appreciate you accepting that that amendment to your motion.
So we have a motion on the floor to table these cases until the next meeting of the board, special or regular. And is there any further discussion?
Chair Dr. Cass, for clarification, didn't that motion include clarification from legal counsel? Was that included in Mr. Crawford's motion?
Yeah. Oh. Go ahead. Member Crawford, did you answer that question? I didn't hear.
Yes, sorry, that is included.
Thank you. All right, so seeing no further discussion, Ms. Barella, would you please call the roll?
Member Crawford?
Yes.
Member French?
Yes.
Member Dr. Cass?
Yes.
Member Nixon?
Yes.
Thank you. That motion passed on a vote 4-0.
All right, that brings us to item F, which is file requests. We have none. And item G, which is the proposed cases for the March 22 review. I believe this should be tabled as well, given that we have not disposed of the cases for February. So this becomes sort of moot. And it's really only a suggestion for the board's consideration in any case as an advance warning. So to item 12, which is reports from subcommittees. So item 12A, the outreach committee sub-report. I believe this is submitted by Member Galloway, and I believe it's a written report. I don't know if she's designated anyone to deliver this, but we can use the written report as the basis for this agenda item.
Chair Galloway asked me to present this report in her stead. There's nothing to add in addition to the written report.
Thank you. So I have so we're at item B, which is the policy procedure review subcommittee report. The subcommittee did not meet this month because of weather cancellation, and I submitted a report based upon the activities that had occurred at APD policy meetings. And so I have nothing to add to that report as well. Brings us to item C, the case review subcommittee report. Member French.
The case review committee met and we presented our final edits and proposal to the board. And the board, most of the board members did meet with city council about our edits and our recommendations and suggestions. And I think the city council will be working on that. And I don't think there's anything else for us to do. I don't remember, Member Nixon. I know we scheduled another meeting for February the 14th, Valentine's Day. But I don't believe we have anything else to do until we hear back or talk to city council again. And if not, then I'd like to cancel that meeting on February the 14th. But I would refer to Member Nixon. Did we schedule that meeting to do more work? Do you recall or?
No, we did not. We finished our findings. I can't remember what we were going to do.
I can't remember either. Do you remember, Ms. McDermott, interim director, what we said on that?
I believe it was possibly, there was no formal that I recall. You did complete your work. You had your special meeting that forwarded those comments to council. I think it was more of a wrap up of how did it go, or if we had any word, which we don't have yet, because of course there was the contemplation that the ordinance would be heard on the 7th. And it was of course deferred. So no, I don't think you had a specific agenda item or anything that you wish to talk about, as best as I recall.
I don't think so either. And so I'm gonna cancel that meeting that's on our right here on the February the 14th. So I don't know if it's Katrina or Valerie who sends out the public meeting notice, but we won't need that for this meeting, for this time. We'll cancel that.
All right, so is that the
That's
end of your
end,
report?
sorry.
Okay.
The end.
All right. So your next duty is to give the next report, I believe, which is the personnel subcommittee.
The personnel subcommittee met and we changed our timeline. We changed some pre-interview questions, and I will be proposing the draft letters to stakeholders and letters to staff, and also the timeline. I don't know if you board members had the opportunity to review the resumes that were submitted to us, but we do have some excellent resumes out there, and hopefully they're still interested, because some of them came in last year. So hopefully these people are still interested in the positions, but I will be going over the proposal, Dr. Cass. So that's the end of the personnel committee, other than we are getting this show on the road, for lack of a better word. Thank you.
All right, thank you. So that brings us to item 13, discussion and possible action. Item 13A is consideration of proposed MOU, the OAB and the APOA on officer involved shooting and serious use of force materials. Council Gooch.
Thank you, Chair Dr. Cass, Honorable Board. Don't have any kind of substantive update other than we are still actively working on it, as Mr. Pacheco indicated in his report on behalf of City Legal. We are trying to meet next week to get through some of the hiccups and some of the concerns of the parties, and hopefully we will have an updated or finalized agreement for the board's consideration, or at least an update about where the lack of agreement might be at the next board meeting. I know that it is a long process, but Dr. Cass and I and Director McDermott are working on it, on the agenda, so that you know that we are continuing to try to move it forward.
So are we Mr. Pacheco, do you have anything you'd like to add?
No, I think that's about it. We're waiting on Mr. Mauer to check on a couple of things. I guess he was unaware of certain practices at the city clerks as far as handing over some video evidence, and so he was going to get back to us, and so we should have some good information after our next meeting with APOA.
Thank you. Is there any questions from the board regarding this? Seeing no discussion, then we will move on to item 13B, which is the draft January to June 2021 semi-annual report. Director McDermott.
Thank you, Chair Cass and members. So the report remained essentially the same with the addition of a couple of pages, and Mr. Abbasi can correct me if I'm wrong, but I believe it was pages 64 through 67 that highlighted the information that Member French had realized was absent from the report in the last meeting. And so we have pulled that information, and that information is being pulled from the spreadsheet that was provided by Council Gooch. Unfortunately, I do not have, again, records, so we are going straight off of the spreadsheet that was last provided. So I didn't want to make any changes. I didn't have any evidence to go one way or the other with it, so it was just pulled straight from the last information. But we have included that for the report so that it is hopefully in line with what was in the ordinance. So if Mr. Abbasi would like to add anything, again, I think he did a good job of trying to incorporate that and make sense of the information that we had available to us.
Good evening, Dr. Cass.
Yes. Go ahead, please.
Yes, nothing what Director McDermott just said. I added the information from the spreadsheet that was provided to me, and the information in the report is exactly the same as it was in the spreadsheet. So if there are any other questions about the report, I'm happy to answer them.
Thank you.
Thank
yes,
you.
Member Nixon.
I was just going to say thank you. Appreciate that. And the turnaround on that. It's really quick. So much appreciated. Thank you.
You're welcome.
And I would like to say
Member French.
thank you, Ollie. And just for your knowledge, I agree. And I put in the edit to take that out of there. I don't think it belongs there, but since we'll do that until we can get the ordinance changed, hopefully, but I agree.
The other comment about the report. I believe this has been, I don't know if this is the appropriate time to accept it, but it has been on the agenda for accepting the report. I believe that it's, we've given notice, members have had an opportunity to review it. And so I would move that we accept the report that has been submitted for the January to June 2021 semi-annual report. Do I have a second?
I'll second that.
Any discussion? Being no further discussion, I would ask Ms. Barella to call the roll, please.
Member Crawford?
Yeah.
Member Friend?
Yes.
Member Dr. Cass?
Yes.
Member Nixon?
Yes.
Thank you. That motion passed on a vote 4-0.
That brings us to item 13C, IMR 14 and status conference update. Ms. Gooch.
Thank you, Member Chair Dr. Cass and board. I provided a summary to everyone after the meeting or the hearing that the court held. If anyone has any questions or like any other details, I'm happy to do my best to answer. And as my summary indicated, there will be a transcript provided by the Department of Justice once that's available to the public.
Any questions from the board? Questions from the board. That brings us to item 13D, Executive Director Selection Process. Member French.
Thank you, Dr. Cass. I did send all the board the proposed timeline and the documents yesterday. I'm sorry if I'm on my iPad, so I can't pull them up. I can't share my screen on the iPad, but I will say that that we said that that we would vote on the pre-interview questionnaires and our timelines. And if we approve those questions, the timelines, that we would ask what is Miss Lonnie Ben, to send out the questionnaires to the individuals and see if they're still interested in the positions. As I said, if you review have a chance to review the resumes, I think that would be a good idea. So if we approve them tonight, the letters would go out tomorrow. We have the 21st as the final applications from HR, and then the board would send them to you. I was trying to look for the special meeting that I told you about. So I guess I was wrong, Member Crawford. I guess our next meeting to review those was on March the 10th. Okay, so I was wrong on that. March the 11th, we have that we would invite the top candidates for the interviews. The week of March 28th, the board would have a meeting for the interviews, and then we would choose the top 3, and then we would make the final discussion. Thank you. Thank you so much, Miss Interim Director McDermott. I appreciate that. So here's the timelines. As I said, we want to get this done. We talked in the personnel subcommittee meeting that this has been lingering since last year. I think the board votes to post the position in May, and then we started getting applications back like in November, December. So anyway, we just want to move this process because it's something that's necessary for the board, for the staff, and city council and on. So this is the timeline that we've set up. Now, I do want to say that the timeline is a draft. It's not set in stone. It's something that we all can work with if you have an issue with the dates or times, and if staff cannot set up for GovTV or whatever, we took that into consideration. I believe Interim Director McDermott was at our meeting, so we know that I'm not sure, but that is a consideration. But these are just recommended dates so that we can get this process moving. So with the next one we have, that was the timeline. And so we have the supplemental questions that we put up there also that we'd like for, Diane, if you don't mind, the supplemental questions for, I think I put it pre-interview questionnaire, I think is how I labeled the document.
Yep, give me a moment and I'll find it. Hold on.
Okay.
Sorry, being a little slow here. Taking a few minutes to get it pulled up. The draft pre-interview, that's what you're looking for?
Yes.
Okay, got it.
They had 11 questions. We went through all the questions, Chair Galloway, myself, and we boiled it down to what we think are the most important questions that we wanted to ask them, pre-interview questions. And the interview questions would be decided on by the board. But these are the things that we wanted to ask them. We didn't want to put them on the witness stand, but we did want some of their ideas on on these issues. And if you read them, you can see, I think that they will give us some idea of where these applicants stand on certain issues. And so this would be the one that we would ask Ms. Lynn to send out to the other candidates that see if they're still interested, and send this out tomorrow. Diane, while we're on this question, during the committee meeting, it was brought up and you had sent the board an email, and I don't know if you just sent it to the board or you sent to all of us, that this position is being underpaid, and that you had looked at other directors or whatever it was said. Ian was in that meeting, that they start out with what this one tops at. And so during the meeting, I had talked about looking into the fiscal, because I know there's salary savings, et cetera. But once I talked to the gentleman, he said that that pretty much was left up to you. You had to put it in the budget. So, you know, we can talk about that later, but I thought that was a very important part, something that you brought up to us. And so I just wanted to say thank you. And I think it's very important, because this is a very important position, and for it to come in making less than other directors, I think is a disservice to the position. So, and not fair to the applicant. So I just wanted to say thank you for bringing that to our attention. Okay.
Yeah, it's been ongoing discussions that we've had with the budget person, the HR person, and it's a multifaceted process to sort of incorporate all of that. But yes, based on my preliminary research, it does appear to be non-competitive, and so that can certainly affect your candidate pool. So you know, it's a question that's being explored between both budget and HR, and you know, whatever mechanism that the agency itself has to, you know, involve in that, you know, we will do so to make it a competitive posting, basically.
Thank you. I appreciate that. And being in the city for years, I know there's salary savings this year that would be easy to pay. I think the obstacle is going to be putting that additional money in the budget for next fiscal year.
Future, right.
So finding that money, but maybe city council will give it to you. You never know. Okay, so next we'll move on to the questions for the stakeholders. Or I should have said the letter, just the draft letter to the stakeholders. And basically, this is what we're telling everybody, including staff, that we're very interested in your opinion, your ideas, what you think would make the ideal characteristics of a good director. As we tell them, their participation in this process is, you know, critical to bringing the best person to this position. So we want to know, you know, do they have interview questions? Do they have opinions? Do they have ideas? What would they like to see in the next director? And as our attorney told us during this subcommittee meeting, the decision and the responsibility is on the board. But we certainly can ask for everyone's input, and we value everyone's input. And I hope that as a board, and we'll look at them in the personnel committee also, that we'll look at all the recommendations and all the questions and give every one of them some serious consideration that we received. So basically the stakeholder and the staff's letter are the same. They say the same thing. They're worded a little different because staff has a little more interaction with this person. And so it was worded, has a little more. We will value staff's opinion to the highest. It's critical for this position. But with that, I think that's all of my my draft. And I would ask that the board accept these documents and that we move forward with getting our executive director interviewed, our interviews conducted, and a selection made in as soon as possible.
And Chair Dr. Cass, Member French, if we could just motion them as listed on the agenda as item D1, 2, and 3 separately.
We can't just say, make a motion that we move on all of them, Ms. Burrell. No, I'm just kidding. So
but for the sake of just
I'll do it. I understand. Okay, so I would ask for a motion to accept the supplemental questions for the applicants for the ED position.
Second. Or so moved, whichever one works.
I'm waiting on Dr. Cass. He has to.
Oh, yes, is there a motion to accept the draft pre-interview questions for executive director hiring process 2021-22?
We're going in the order. Did you name that one, Dr. D? What? Yes.
Isn't that
Consider it.
I'm sorry, the draft pre-interview questionnaire, is that?
No, there's a motion to accept the supplemental questions for the applicants.
Oh, okay, all right, sorry. So there's been a motion and second for the supplemental questionnaires for applicants. I thought, all right. So discussion. So I'll recognize myself for purpose of discussion. This is, I just want to make sure I also have these documents up, and I just want to make sure I'm looking at the right one. I'm sorry, is this a staff invitation letter or the draft pre-interview?
Pre-interview, we just want to get these this is part of Eric's original process to send the applicants interview questions. This is the pre-interview
Right.
questionnaire is all this.
I just want to make sure we have the document on the floor here. That I'm looking at a document on my screen. I just want to be sure it's the right one. So my comment about this is that this lacks a question dealing with oversight. Essentially, there's the purpose of this board is constitutional policing, and yet there's nothing in here that even mentions the factor of constitutional policing and oversight experience. And so I think this is certainly presumably this is still a draft and it's not a set of closed questions. I know I proposed a question on oversight. I don't know if that was rolled up into what the committee considered or not, or whether that actually got as far as the process, because it was done several months ago. But that's my, this seriously needs a question regarding police oversight practices and experience. So that's my discussion about this item.
It's in their resume, Dr. Cass, but this is just a pre-questionnaire, but if you've looked at the resume, all of them have it in their resumes. But
I'm sorry, I have looked at the resumes and I did not see that much I did see little mention of police oversight experience.
Okay, well, this is just a draft. I'll pull the letter up. We need to get this done. Just tell me what your question is and we'll add it to the draft. Okay.
My question is, what is your experience with police oversight and constitutional policing issues?
Okay, Dr. Cass, I'm more than happy to add it. And I'll change my motion to accept the this document with the added question. What is your experience with what? Say it again, Dr. Cass.
Police oversight.
Civilian police oversight.
Okay. That's it.
And
constitutional police.
Constitutional. Say it again. Constitutional what?
Policing.
Policing.
Thank you. All right. It's there.
And if that's the case, I second.
All right. Any further discussion on accepting this pre-interview questionnaire? All right. Seeing no further discussion, Ms. Barella, would you call the roll, please?
Member Crawford?
Yes.
Member French?
Yes.
Member Dr. Cass?
Yes.
Member Nixon?
Yes.
Thank you. That motion passed on a vote of 4-0.
Thank you, Dr. Cass. Our next one is, I'll make a motion for, to follow the timeline as it currently is. And the motion, and with that motion, if something comes up, we will be flexible. But currently, we're going to try to, the motion is to use the timeline that is proposed, but that the board will remain flexible if things occur that we're not able to meet on those days, such as GovTV.
Reword your, is a friendly amendment. Could you reword your motion to say that to accept the timeline as a guide for the hiring of the executive director?
Absolutely. My motion is to use the timeline as a guide. I think is better than the way I had put it. Thank you, Dr. Cass, for rewording that for me. To use it as a guide. Okay, thank you.
So there's a motion on the floor and second to use the timeline as a guide for selecting the executive director position. So is there any discussion? So I have a comment, and that is, I think, you know, I'm concerned that this process needs to be done right, and I think, you know, it has gone on for a long time, but the fact that there was a long delay at the beginning of this shouldn't mean that we rush to hire an executive director at the end of this, given that there's a couple of things under consideration. First of all, significant ordinance changes, which may change the requirements for an executive director to allow Ms. McDermott, for example, to apply for this position. And I think that's a candidate who I believe should have consideration. And then the second is that I think there needs to be more consideration for what, you know, the fact that we are a board of about half strength and that we expect 4 or 5 new members on in the next couple of months. That's the board that's going to be operating with this new executive director. And so it seems to me that there should be some consideration for meshing the hiring of a new director along with the fact that we're going to get a significant number of new board members. So I'm concerned that this process at this point is moving too fast. And so I would suggest that we slow the process down a little bit to see what transpires regarding ordinance changes and member selection.
Dr. Cass, we're not rushing this process.
Is there any other discussion by the board? Member Nixon?
I disagree. I think that the timeline that we have is just fine, regardless of how many members we have on the board or whatever changes are going. This process is parallel, but it's separate. And I think that whether we have a 5 on or we get the full board is irrelevant to the timeline because we have to work with what we have at that time. So I don't see where we'd have to delay it in order to get more people on the board in order to hire get an executive director here. As far as whether or not Director McDermott can apply for the job, I didn't, and you can correct me if I'm wrong, Member French, but I didn't know that there was anything that precluded her from doing so, especially the fact that we have it taken away from the requirement, the need for a Juris Doctorate.
Well, that requirement has not been approved by council, okay? And we don't know when it'll be or if it'll be. Okay, there's no assurance that's going to be done. But with that being said, the issue that I have with that is we should not slow down this process. And I'm not saying that she's not to give one individual an opportunity to apply. I think that is almost interfering with the integrity of this process. And so we're not rushing it, Dr. Cass. As I said, if you look at the timelines, it's not until March that we actually do the interviews and make the selection. This is the end of March. I think it's March 28th. So it's no rush to this process. And I think setting it back for one individual is not what this board should be about. I think that we need to move forward with this, and we don't know. Like I said, the city council might do it, and then they might not. So we're going to slow the process down based on an assumption. So you know, that's all I'm saying, and I just don't think that that's what we should be doing. So I think.
Thank you. So is there any further discussion? Director McDermott.
Thank you, Chair Cass and members. Just to be clear, I just want to make it known that this is not a request that I am trying to push for or make in terms of having the ability to apply or not. So I do want that to be clear. There is no attempt here to try and change a process for a personal accommodation or for a single person. However, you know, there are ordinance changes that may affect your candidate. So that's all I'll say, but I'm just saying that, you know, speed, fast, slow, however you want to go, obviously it's the board's decision, but I did want to make it clear that this is no personal agenda attempt to have any favor for me one way or the other. So.
Thank you.
All right. Any further discussion by the board? Member Crawford, we haven't heard from you yet. Here's your opportunity.
Yeah, you know, I'm a little bit on the fence on this issue. I'm really reticent to delay the timeline on this because number one, there's kind of the 6-month thing to make us all nervous, but probably more importantly, I do just think that given that the agency is a little short-staffed and everything, we're kind of suffering from having the lead investigator also be the executive director. That said, it is true that if the ordinance amendments go the way we expect, it might expand our applicant pool, and that would be a good thing. I guess I'm kind of sympathetic to both sides here, but I think on the balance, I'm leaning towards keeping to our existing timeline.
You're leaning towards what? I didn't hear you. I'm sorry.
I think he said the existing timeline.
Okay.
So,
Member Crawford, we're not able to hear you.
Yeah, he's on mute.
No, he's not on
Full
mute.
city council will approve them next week, but or not next week, but next month. But you know, I'm not sure when that will be effective, and I think we might get ourselves into trouble if we try to hold our breath for that to happen.
is there any further discussion on this? So, seeing no further discussion, Ms. Barella, will you call the roll?
Member Crawford?
He disappeared.
Member Crawford?
Yeah, I think he's dropped out, so we'll have to wait till he signs back in.
Be back, call him at the end, please. Maybe that'll work.
Okay. Member French?
Yes.
Member Dr. Cass?
Yes.
Member Nixon?
Yes.
I'm sorry, I think you might be waiting for my vote. It's a yes.
Thank you. That motion passed on a vote of 4-0.
Okay, we're at the next item on your agenda.
Sorry, Member Chair Dr. Cass. Is it possible to go back to item D1? The motion was to accept the supplement questions. Never mind. I'm sorry. I'm not there yet. Disregard.
The motion was to accept the supplemental question with the addition of the question from Dr. Cass.
Right. Okay, yeah, and that is correct. But for clarification, who's going to send those out? Were we directing it to any one person in HR?
Yes. Yes.
That wasn't in the motion, so I just wanted clarification on who's responsible. Is someone going to sign those letters? Is that going to be acting Chair Cass, or is that going to Chair Galloway? Those are just clarifying questions that I needed for D1 for the record.
May I speak, Dr. Cass?
Yes, go ahead.
Yes, that was my next motion that I was going to make. During our meeting, we said that the HR director, Ms. Lonnie Ben, would send those letters out. She would contact the applicants to see which ones are still interested. I don't know. I guess we could do digital signature or whatever if Chair Galloway needs to sign the letter. But according to our timelines, we would try to get them out tomorrow. And so that's why I wanted them all to be there exactly what they should be and just have to put it on letterhead and get it. Dr. Cass, do you know? Well, either way, she can get an email so we can do a DocuSign. Diane, were you talking to me?
Well, I was going
Let's go ahead. Yeah,
propose
yeah.
a suggestion. So yes, if you could basically state those in a document to whether it's coming from Chair Galloway or since you're the chair of the personnel, I believe it could come from you. But if you provide that in a document, then we'll go ahead and put it on the letterhead, have you, do the DocuSign thing, and then I can forward those to Ms. Ben with the understanding that that's what the board has desired and that they want those questions to go out to the candidates. So I just, to be clear on the process, and that's what we can do if that's amenable to everybody.
Sure, that works for me. Now, Diane, let me ask you one other question. When we're contacting these applicants, in the bottom of the timeline, it says that wages may be negotiable. Will we know how soon before we'll know from fiscal or whatever? Because what he told me is it's left up to you. But I know what the process is. Don't get me wrong. I know what it is. You have to put it in the budget. You have to find the money. So with that being said, I'll go back and clear up Valerie. So do we need a motion to do that, Dr. Cass, or can we just say, I'll get the letter to them and they'll send it out, send it to Miss Lynn tomorrow?
It seems, hasn't personnel been, the personnel committee been handling this up to this point and contacting the
Yes.
HR? So it seems that ought to continue that along those lines.
Yeah, the usual proper way would be just that, we'd receive it from the subcommittee, then, we would go ahead and send it to the HR person that's been assigned to do this, with a CC, just basically like we did for the council suggestions. The agency forwarded that, as the board all saw, to President Benton. So this would be a similar process, that we would have this letter essentially from the chair, and then it would go to Ms. Ben via, me sending it in an email so that you would see that that's been done. So that would be the kind of the best way to go about it, so that we can make sure that there's clearer chains of communication on it.
So what is left? What is left for that you need to have approval of the board?
I think it was just Ms. Barella was just looking for clarification on what to do with it. I don't know that necessarily was a motion per se that needed to happen. It was just clarification of who was responsible for that task, is if I'm correct.
Okay, thank you. So we're finished with that item, and now I'm directing my question to Member French as to what other items are left with on your agenda item to be approved by the board. Does that take care of your?
That takes care of all of them.
Okay.
I think we did. Did we not? Are we on?
No,
Which
we're
one
on
are we
number item 3,
Three?
consideration of communication to stakeholder groups.
Okay, I'm sorry. So we did the letter. I'm so sorry. Okay, so a motion to approve the stakeholders group letter to be sent out also.
Second.
There's a motion to approve the draft stakeholder invitation letter to be sent out. Is there any discussion? Being no further discussion, Ms. Barella, would you call the roll, please?
Member Crawford?
Yeah.
Member French?
Yes.
Member Dr. Cass?
Yes.
Member Nixon?
Yes.
Thank you. That motion passed on a vote of 4-0.
All right, we are at item 15 or 14, other business.
Go ahead, Ms. McDermott.
Ms. Barella.
Yeah, it was just for me, actually. Chair Dr. Cass, sorry. Just so that everyone is clear on the clarification again. So Member French, if you want to draft those as actual letters, we'll put them on letterhead. And then we do have the amici group like list. I assume that you want it basically to all the amici, or did you want to specify which amici? I don't recall if the subcommittee limited it or if they just wanted it kind of to all the groups that are most typically recognized by like Miss Martinez from the DOJ and things like that.
You know what, I would say send it to the ones we have in the past. I think most of the CPCs and all of them have chairs. Can we send it to the chairs or vice chairs of these groups? I'm not sure how all of them were set up. But with that being said, I'm sorry, all of them aren't here. So the letter to the stakeholder and the staff are basically the same, but I did not add that to my motion. So I would, on that last one, Dr. Cass, if you don't mind, I know we voted on it, but I need to re-vote on it because it has, I just said stakeholder and I didn't say also staff. And there is, you know, we saw the draft letter going to staff too. I don't know if that's necessary, but I mean, they've already read it already, but I just wanted to be clear on the motion. Ms. Varela is stickler for our minutes.
So, all right, Council Gooch, we need your opinion.
I would recommend you continue with the current vote and then do a second vote for the CPOA staff letter, since they are separate documents, just to have a clear record.
Okay, it wasn't on the agenda, so I didn't know if I could do it as an action item. Okay, that's fine.
So that means, are you making a motion to?
Yes, I want to make a motion that we approve the draft, the letter to the staff asking for their input.
I'll second that. Discussion? Seeing no discussion, Ms. Brella, will you call the roll, please?
Member Crawford?
Yes.
Thank you. Member French?
Yes.
Member Galloway? Oh, I'm sorry. Member Dr. Cass, Ms. Galloway is not present. Member Dr. Cass?
Yes.
Member Nixon?
Yes.
Thank you. That motion passed on a vote of 4-0.
Okay, that brings us to item 14, other business. Is there any other business? You lit up, Member French. Oh, that was an accident. Okay. All right. Seeing no other business.
Dr. Cass, I would like to say one thing. I just want to thank the 2 new board members for sitting and staying with us throughout this entire meeting. I know it's a long one, but I just want to say thank you. We appreciate you wanting to serve on the board. It is time consuming, but we do appreciate you being here and sitting through this.
Hey, you're welcome.
And I'm glad you brought that up, but I disagree. This is not a long meeting. This is a short meeting, but I'm just kidding. We'd like to make all our.
No, he's not.
We've had longer meetings. I guess that's the answer. But we're trying to do better. So I agree with the sentiment. I would like to thank you for attending and persevering. So and we look forward to you joining the board. So is there any other business? All right, seeing no other business, no other comments, I'd like a motion to adjourn this meeting. Our next meeting is on March 10th at 5 p.m. So I make a motion, we adjourn the meeting. Do I have a second?
Second.
Please, thank you. All right, Ms. Brella, will you call the roll?
Member Crawford?
Yes.
Member French?
Yes.
Member Dr. Cass?
Yes.
Member Nixon?
Yes.
Thank you. That motion passed on a vote of 4-0 and the time is 9:14.
And the meeting is adjourned. Thank you. Good night.